May I permit to mention, my lord, for listing one matter, my lord, senior citizen matter, my lord, 75 years old and suffering from various ailments, my lord.
You have served notice upon the other side.
Yes, my lord. My lord, definitely.
My lord, may I be permitted to mention for inclusion, my lord?
Have you served notice upon the other side?
Earlier served, my
No.
lord.
May I have your lordship's leave to mention one matter for inclusion, my lord? I am mentioning on notice, my lord. But the matter is ready for hearing, my lord, and may be included in the list. Much obliged.
Yes, call the list.
Item number 1 for correction.
Correction আছে এটা 22 হবে this matter was directed to appear under the heading to be mentioned for correction of a typographical error which has crept in the year of the writ petition. Writ petition number. Full stop. The correct number of the writ petition is WPA 22590 of 2022, but it has been inadvertently recorded as WPA 22590 of 2024 in the order dated 7th of January 2025. Let the aforesaid error be rectified. First of this order shall form part of the order dated 7th of January 2025. Call the next matter.
I am the state, my lord, in this matter.
Yes.
Item number 1.
Call the next matter.
Item number 2.
Item number 2 and 3, my lord. Mr. Santanu Das, advocate and record, my lord.
Yes.
He did not come to court, my lord. Kindly adjourn for the day. And there was submitting a report from the states, my lord. They have not it served. Report was called for the state, my lord.
Yes, Mr. Samantu is appearing for the state. Let me
Yes.
see whether the report has been filed. Passover next. 2 and 3. In both the matters, report was called for.
Yes.
2 and 3 Passover. Next.
4.
Lordship, I am submitting the opposition, Lordship.
None appears for the petitioner at the time of call. Mr. Ahmed Laner, advocate, appears for the state and files the affidavit in opposition of the respondent number 4. Let such affidavit be taken on record. Have you served a copy of this affidavit upon them?
Lordship.
First up, let affidavit in reply be filed within a week from date.
He has,
List this matter. He has filed a reply,
Lordship, he has served a reply,
but he has to file. It is not on record.
Lordship.
আচ্ছা তাহলে একটা লিখুন Mr. Ahmed Laner, advocate, ওটা কেটে দিয়ে লিখুন Mr. Ahmed Laner, advocate, appearing for the state submits that the copy of the affidavit in reply has already been served upon him. First up, list this matter in the next week. First up, on the next date, the learned advocate for the petitioner shall file the affidavit in reply. Next.
Madam.
5,
Passover.
6,
Passover.
7,
Passover.
8,
Paying for a short passover, my lord. My senior Mr. Shomu Mojumdar is appearing for the petition.
Passover. Next.
nine,
Well, it's my application for restoration. But I draw your lordship attention the impugned order. But the petitioner was appeared, praised for time, but the learned judge dismissed as non-prosecution. But on that ground, on the earlier occasion, the petitioner was not appeared. But fact is that those days are
Present, if he is not willing to proceed, what can be done? It has.
no. No,
That
on
has been
3 days,
recorded.
3 regulation has been taken by the bar. Well, on that, if your lordship,
Have you served
yes,
copy upon the other side?
yes.
Who is appearing for the other side?
Well, the other side, affidavit of service.
Who is appearing? Who is the learned advocate?
Well, the by hand I also in serve upon them. Bolai Chandra Pal, Niladri Karan and Ruma Sarkar for the respondent number 2 and Sushobhan Sengupta and Subir Pal for the state.
What are you challenging? What is the challenge in the
The
writ petition?
challenging the computation of the award passed by the tribunal. The tribunal has been passed the order award in favor of the petitioner. That has against that a writ application has been filed. That writ application has been dismissed and ultimately filed an application for computation of the said award. In the computation, the wrongly incorporated sum of the award amount. Against that, the petitioner came filed this application.
Show me what is the mistake in the award.
This is the order, is page 85.
85, yes. Where is the calculation?
The calculation, the decision with reason, the last portion, I refuse to accept the application's claim.
Directed to pay 4,63,000.
Yes, whereas my client calculation, near about 40 lakhs.
Where is that? Where is that? Where is that you have placed before the authority that your claim is 40 lakhs? Show me that.
Page 68, 67, 68.
No. Show me that in course of hearing it press that. Show me.
No. Question is the if
At the time of hearing,
yes,
did you place your calculation?
yes.
Show me that.
The
How it has been considered by the authority.
authority means the tribunal.
Yes.
Page 66 and 67 and 68.
No, the impugned order is at page 85.
Yes.
There the calculation which has been made is 4,63,000. According to you, your calculation is 40 lakhs. Show me that you have raised that point that you are entitled to 40 lakhs.
But if your
Before
lordship
the-
kindly taken up tomorrow, I only came before your lordship on the restoration application.
No piecemeal hearing.
If your lordship because on the earlier 2 or 3 days before I ready.
The writ petition of 2022 be prepared with the main matter, not with the restoration application only. Nothing. It does not appear from the order that you have made
No.
that you are entitled to 40 lakhs.
Yes. If
Show me that.
if your
Where is your claim which you have made? 40 lakhs claim.
Page 86 and the last paragraph, in the instant case, no pay slip of the applicant has been furnished by the workman and substantiated his monthly wages of rupees 1070.
So if you have not placed that, how can it be computed?
No, that has been placed. In the year 1985, my wages was 1070.
Have you placed any document? This is the finding that we have not placed any document.
I placed those documents, but I have been suspended since 1985. At the time of one suspension, I was 1070 my wages, and at the time of computation, the landed judge calculating that my remuneration was 1070. But Exhibit 6 of the letter 9th of August 2004 disclosed the fact that for the month of July 2004, workman was paid 1070. This Exhibit 6 has strongly corroborated the claim monthly wages of the application to the tune of rupees 1070 only prior to his termination. But applicant in his claim amount demanded yearly increment of rupees 600. Contending that yearly increment comes within the purview of the consequential benefit as awarded by the learned trial industrial tribunal. Surprisingly, no document has been submitted by the workman to show that this yearly increment of was 600 exhibited 4 and 5 at the payslip of two different workers. The learned advocate of the workman tried to convince this court that those works were junior to Sri Jogendra Singh, and pay scale of the Jogendra Singh should be higher than that was Mr. Singh and Ramji Singh, whose pay slip have been produced before this court. The date of joining of those two workers are not reflected in the document placed before this court. So this court has no scope to check the veracity of the claim of the applicant that he is entitled to get higher pay scale and Mr. Singh and Ramji. Further, applicant has failed to furnish any corroborated documentary evidence to show that his claim of yearly increment of rupees 600 is correct. Mere claim of the applicant is entitled to yearly increment of rupees 600 is not enough to substantiate his claim amount. So on the basis of the surmise and conjecture, I refuse to accept the applicant claim a yearly increment of rupees 600. Instead, he dues ways of calculated monthly pay 1070 as reflected of exhibit 6. Therefore, applicant's dues wages would be rupees so and so. Well, in the 1985, my wages is 1070, and at the time of computation, that also been calculated 1070 on the basis of that amount has been came.
What is the yearly increment? You have not produced any document to
But I have been
substantiate.
suspended it in 1985. What and in what manner? But
As
it
per
is
your service condition that you are entitled to increment of 600 per year, you have to substantiate that.
Malad,
It may be 600, it may be 500, it
500,
may be 400.
but I
You have to
ask
su-
myself,
But you have to produce some document.
where from I collected? But it is not possible. I produce another laborer, those the Mr. Singh and Mr. Samji.
His date of appointment was not proved. That is the finding. You have not produced that.
But in the year 19,
Whether he was senior, whether he was junior, whether you are entitled to that, burden of proof lies upon you.
certainly, but,
But you have not proved that. That is the specific finding.
on the basis of that, those two documents have been produced.
Maybe,
But
but
they are the
whether
junior.
those are applicable or not, there is a specific finding. Show me that yes, you have produced that their date of appointment. There is a specific finding. in
That
this
date of
record.
appointment, what I am,
It's a factual
in the year-
finding, sir. Unless
Certainly.
you show that it's perverse, how can a Writ court interfere with that?
in the year 1985.
Unless you show, yes, you have produced these documents, other documents to show that your yearly increment is 600. This, unless you can show that, yes, their appointment and your appointment was at the same point of time, how can the tribunal take into consideration that document? This is a specific finding. You have to show what was the document produced by you. Show me which document you have produced of those pay slips. Exhibit 4 and Exhibit 4/1.
A person who is appointed in the year 1985.
Maybe, but how can I say for the purpose of holding that it is wrong, I have to give some reasons. Writ court is not a court of appeal.
No.
So
This
you have to show the infirmity in the order.
infirmity in the order is that in the year 1985, I was wages 1070 and 2015.
But you have to show, maybe it's not to 1070. But
it is,
what is that is, you have to prove that as per your service condition, you are entitled to 600 yearly increment that you can produce.
in the manner of the another two workers, they have been produced some documents, but
Show me what is the document you have produced. What is Exhibit 4 and what is Exhibit 4?
that is the call for the record. Otherwise,
No.
I have no
Calling for the records. You have produced the
But that-
document. You
that-
must have. You have
that
produced.
particular findings of the learned judge. That those people.
4 and 4/1. You have produced that document.
Yes.
To produce that.
Very well, but if your lordship kindly adjourn this today, I
Yes,
take
Ashwin.
into instruction.
The learned advocate appearing for the petitioner submits that he is not ready with the main matter and he prays for some time to take instructions from his client with regard to some of the documents which were placed before the learned tribunal. As prayed for by the learned advocate for the petitioner, lists the application in the next week.
Next week.
Under the same heading, bole deben. Every service filed in court today is taken on record. The learned advocate appearing for the petitioner is directed to communicate the next date of hearing to the learned advocate appearing for the respondents in course of this day. Yes,
Possible matter, you will take a possible matter. Possible matter, you will take.
wait for your chance. Let me run through the list. Yes, next.
10 and 11.
There is.
My lord, item
Get
number-
full, your lordship.
My lord, item number 10 and 11, Mr. Tanmay Mukherjee is appearing on behalf of the petitioner, my lord. I am praying for not today, my lord.
Who is appearing?
Tanmay Mukherjee, my lord.
Why not
My lord,
today? You are
he-
here.
He is engaged in another court, my lord. I am not AOR, my lord, in this matter. I am not briefed in this matter, my lord.
You are not briefed.
No,
You are
my
his
lord.
chamber junior.
His chamber university is
Now the chamber junior are to be briefed separately in appellate side. Unheard of. We have not heard this. I don't know whether Mr. Banerjee has heard this also. In appellate side, all the chamber juniors are to be briefed separately. Yes, Mr. Mukherjee, you are following a procedure that all the chamber juniors are to be briefed individually in your Seresta.
But this is not my Seresta's brief. But
Even not, the chamber juniors will not look.
no, that is not even I
You
have
are
been
following
briefed.
that practice.
But even I have been briefed, Lord, quite a days back. Lord, what happened, Lord, I am telling before your Lordship, Lord, item number 10 and 11, both are, Lord, analogous matter.
Yes.
In respect of one tender, Lord, initially, that was being, Lord, cancelled by invoking one of the clause. That was not correct. I approached before this honorable court, Lord, that cancellation was being stayed. Thereafter, they have come up with a modification application showing one of the clause of the tender document that even without cancelling, since it's a public project, they can carry out by engaging new person, new contract to complete the public work. But the court considered that clause is there. So my cancellation, they themselves said, we are not going to invoke that cancellation clause. So that goes, they are being permitted, that interim order was being modified. They are being now permitted to carry out the rest of the work by engaging new contractor, invoking that clause. That was being done. Subsequent to that, what happened? There are invocation of the bank guarantee. I approached this honorable court by filing a fresh writ petition that they cannot touch my bank guarantee since cancellation clause has not been invoked. There also I got an interim order. That is the second writ petition before your lordship. There also affidavit directions are there. Today, everything boils down that I cannot go on working because rest of the work is being done by engaging new contractor. My cancellation chapter goes because they have not invoked that clause while modifying the earlier writ petition, that is item number 10 before your lordship. They invoke the second clause wherein they are being permitted not being cancelled my tender process. They are completing the work by executing, by engaging new contract. So now everything boils down with regard to the admitted amount. Because today they cannot invoke, they cannot cancel anymore. They have taken their chance. They have said, no, we are not going to invoke that of the cancellation clause. Instead of that, we are invoking this second clause. I will show before your lordship what is the admitted amount after exchange of affidavit. Lordship fixes any day after the week.
What is the admitted amount?
I will show that is the affidavits they have also have to be filed. All the parties have used their affidavit. Mr. Arifin is there,
So you are only claiming the admitted, not the damages.
Admitted amount at least before this honorable court, because your lordship knows.
Claim, Mr. Mukherjee,
because
that is
disputed.
If you are claiming damages, then no piecemeal adjudication.
I bow down before your lordship. A writ court jurisdiction, regarding that I am not conscious. That's why I restricting myself.
So if you restrict your claim to the admitted amount,
I shall.
So from the pleadings, this is
yes,
the admitted amount.
Yes. That will be my endeavor. That will be my endeavor before your lordship.
You have to forego your other claims.
Other claims, regarding that, I can approach before the appropriate forum, not before your lordship.
Do everything before that.
I shall come back.
Not a piecemeal.
Kindly.
Here you will be taking admitted. There will
But
be.
your lordship, kindly consider, my predicament. I have admittedly done, my major portion of the work. Thereafter also, that cancellation has not.
I appreciate that. But the question lies, now your remedy boils down to the damages.
Yes.
So damages will include a part this admitted amount.
Damages, is one component regarding where, I have not been permitted to, do the rest of the work.
Mr.
But
Mukherjee,
regarding the work I have done.
There may be what you are claiming, a part of that admitted.
That's
A
why.
part, kindly consider this, a part is disputed and another component is damages.
Yes.
So if the civil court or the appropriate forum can decide all
But
these.
if in this process,
all these,
I bow down, I appreciate.
decide in a peaceful manner.
No, I am not really asking your lordship to decide something in this writ petition. I say, if from the exchange of affidavit I can show before your lordship.
I appreciate
that part, let them disburse. I shall fight it out, Regarding that part, at least, I am entitled to, because today they cannot invoke the cancellation clause. There is no cancellation at all. For that reason, I will have to show before your lordship.
That is why I asked you whether you are invoking the damage clause or not.
My lord,
Or you are-
that, my lord, I am entitled to. I must be, my lord, bow down before your lordship regarding that portion. I am entitled to. But regarding the writ court jurisdiction, how far it can be stressed, my lord, regarding the damages, my lord, I am conscious of that. But I will not trouble your lordship regarding the exchange of affidavits being done. I shall, my lord, deal your my lord, I shall, my lord, invite your lordship to only those part of the affidavit wherein, my lord, the admitted portion is there.
Also take instructions whether your client is willing to forego the other part by accepting this.
Well, I shall.
Because it's a question of discretion, Mr.
Definitely, my lord. Definitely, my lord. That's why,
So-
my lord, I will invite your
if-
lordship. If your
So
lordship,
discretionary relief, if the composite relief can be granted by an appropriate forum, including this, whether the writ court will entertain such a writ petition.
well, I shall
Bring those line of
I
judgments
shall try.
also.
My-
Ashwin. Mr. Mukherjee, learned advocate appearing for the petitioner, submits that the relief. Mr. Mukherjee, kindly hear this, that the relief which the petitioner is at present entitled to is the admitted amount on account of the work executed by the petitioner. First up, he however plays for some time to go through the relevant papers. First up, as paid for by Mr. Mukherjee, list this matter. Monday,
Lord, next week I will not be there, my lord. Any day, my lord,
Why?
after.
where you will be?
Lord,
Court is closed from next week.
no, my lord. For my lord, the holy
Entire
Sunday,
next week you will not be there.
entire next week, my lord. I may come, my lord, on Friday, but that is uncertain. That's why, my lord, fixes any day, my lord, after Friday.
Court will be on holiday, Mr. Mukherjee.
No, my lord, the auspicious day, my lord, doesn't come, my lord, in between the holidays. My lord, 29th, I will be in Kumbh. That's why, my lord.
All right. That is a good ground. As paid for by Mr. Mukherjee, list this matter in the week starting from list this matter in the monthly list of February 2025
Great.
under the same heading.
Great.
Yes, next
10 and 11, my lord, both same.
10 and 11. The
Great.
learned advocate on record of the petitioner is directed to intimate the next date of hearing to the learned advocate appearing for the respondents and file an affidavit of service on the next day. Next,
12. My lord, in this matter, I'm appealing for the petition, my lord. I'm paying for not today.
why?
My lord, I'm not taking up my brief, my lord. I'm not.
You don't have the brief?
Yes, my lord.
Go through my brief. I'm passing it over.
No, my lord, in this matter, the matter is relating to termination of a employee of a cooperative society, my lord.
Yes.
My lord, there is no defalcation charges, nothing. The allegation, there are 33 allegations and they are proved, but no defalcation charges. My lord, I have to file a supplementary affidavit because I have to add some documents. Who is the man?
Who is appearing for the respondent?
Mr. Milan Bhattacharya. Sir.
Lord, I appear for the state, Lord, Additional Chief Secretary, Cooperation Department. In fact, directly have got nothing to say on the matter.
Yes.
issue. But
This
it
is the cooperative society who is the answering respondent.
Lordship. It's entirely, my lord, for the society to answer. And
What is the punishment imposed?
My lord, terminate.
Termination.
that is only covered under the rule framed under this act, my lord, 106.
Yes, I have already applied before the general body, but general body also.
Rule 06, my lord, says the penalty and all.
You have exhausted the appellate remedy also.
Yes, my lord.
No,
Affirmed.
appeal
Mhm.
this point of.
General body over this.
Any revision provided under this
No,
statute?
no. Now,
Lord, as such against this, my lord, no further
No revision.
no further appeal.
I'm led by Mr.
What was the charge against you?
My lord, certain loans has been given by the board that were not recovered. Allegation is coming upon the only
Post you are holding?
manager.
Manager. All right. As paid for by the learned advocate for the petition, hearing of the matter stands adjourned for the day.
My lord, kindly give a liberty to file a supplementary affidavit.
The petitioner will be at liberty to file the supplementary affidavit, annexing only the documents which were part of the proceedings
Yes, my lord.
in the inquiry proceedings and have not been enclosed in the writ petition.
Yes, my
At liberty to, my lord, to file rejoinder if any.
Mr. Nayak, what rejoinder he will file?
Only
Can you
documents.
improve upon? That is why I have restricted him to only those documents which are part of the inquiry proceedings.
Lordship.
How will you improve by filing of an affidavit?
I do not know whether what,
Mechanically, don't pay for filing of affidavits and reply.
Lordship.
In the departmental proceedings,
even
only
my lord-
the documents which are part of the departmental proceedings, nothing else can be looked
Only
into.
to ascertain the documents are really
Yes, sir.
exchanged by
If
the.
you have some more documents, you can enclose by way of a supplementary affidavit. I will accept that,
Great.
or by way of a compilation.
Lordship.
Don't
Lordship.
include these affidavits mechanically in all matters. Yes, next.
Great.
13, yes. Who is appearing?
ও সোমবার থাকবে ঠিক আছে Great.
Passover. Next.
My
Lord, I am appearing for the petitioner, my lord. This is a contempt application, my lord. On the last occasion, the alleged contemptor did not appear. Your lordship was pleased to observe that on the next date, if the contemptor does not appear, then a stringent order shall be passed, my lord. Lordship, although there was no order as such, but my lord, I have communicated the order copy, my lord. This is my affidavit of service. It was not a part of the order, though. There was no such order, my lord, but still I have communicated the order, your lordship, to the alleged contemptor. You know, the several times the alleged contemptor has been served, my lord, but they're not appearing, my lord, in the contempt application.
What was the direction?
Lordship, to consider the representation, my lord, the original order of the order date was 19th of July 2019. The writ order
19th of July.
2019. It is at page 29, my lord. And subsequent to
Page
that, the
29 of the contempt application.
contempt application. Subsequent to that, there was also a correction order, my lord, at page 31.
Ashwin. This is a contempt application alleging willful and deliberate violation of the order dated 19th of July 2019 passed in WP 21847 within bracket W of 2017. First up, pursuant to the order dated 4th of November 2024, the petitioner served a copy of the contempt application and an affidavit of service in that regard was filed on 26th of November 2024. First up, on 26th of November 2024, the alleged contemptor was not represented. First up, in order to enable the alleged contemptor to be represented, this court adjourned the hearing of the contempt application for a period of 2 weeks. First up, the learned advocate appearing for the petitioner submits that the said order was duly communicated to the alleged contemner, namely Srimati Bulu Bishas, and an affidavit of service has been filed in court today, which is taken on record. First up, today also none appears to represent the alleged contemner. First up, in view thereof, this court is left with no other alternative but to issue a rule against the alleged contemner. Let a rule be issued, returnable 4 weeks.
Gratefully.
Next. For the next matter.
15.
In this matter,
Lordship, item number 15, I am for the alleged contemner, Lordship. The order has been duly complied with. Lordship, may the matter may take up at 2 p.m. Lordship. I mean,
No, no, no. My lord, in this matter, my lord, in the writ petition, I was the private respondent. My lord, against your lordship's order, the appeal was prepared, which is pending.
He says he has complied with. You are saying, I'm keeping it at 2 p.m.
Okay, my lord.
In his presence, I will pass an order.
Lordship,
Yes, next.
Lordship, great.
16.
My lord, I am appearing on behalf of the petitioner, my lord. On the last occasion, my lord has directed me to serve it on the contemners as well as the erstwhile advocate and records. I have served that. This is my affidavit of service, my lord.
Mr. Chatterjee was the alleged contemner.
Lord,
Fact remains, my lord, they have preferred an appeal against, and that is,
we are little
though
bit
not
of time.
appearing, no
We have-
stay, nothing has been granted.
We have
but,
mentioned it. My lord, it's been,
An appeal has been filed.
I'm aggressively, my lord, mentioning the matter, my lord, so that it can be listed, my lord, as fast as possible.
Give me the number.
Appeal number.
Mat 1181.
কোথায় গেল?
Appeal number. Mat 1818.
MAT MAT number 1818 of 2024 and
Ashun.
FMA number
Mr. Chatterjee,
1227.
learned senior advocate appearing for the alleged contemner, submits that you are representing all the 3 alleged
No,
contemners.
2. 1 and 2.
1 and 2. Alleged contemner numbers 1 and 2. Who has preferred an appeal?
I.
Alleged contemner numbers 1 and 2 submits that an appeal has been preferred against the judgment and order dated 16th of August
Yes.
2024, being MAT number.
1818 of 2024.
First up, his FMA number পড়ে গেছে?
FMA, my lord, is 1227 of 2024.
He submits that the appeal is expected to be taken up for hearing within.
It's difficult for us to say, my lord. We are mentioning the matter. It's very difficult for
When
me.
do you want this contempt to be taken up?
He said, my lord, end of February.
Mr. Chatterjee, learned senior advocate, submits that the appeal is expected to be taken up for hearing shortly. First up, in view thereof, list the contempt application in the monthly list of March 2025 under the same heading.
So grateful to you.
What is this you have filed?
And this is the affidavit of service, my lord.
So if it is service filed in court today, is taken on record. You are for the
I am for the alleged contemner number 3.
Acha, alleged contemner number 3 is also represented by the learned advocate.
There's something wrong with the eye.
Lalo hai.
Lalo has.
Yes.
Okay.
Next.
FMA.
17.
Briefly obliged.
FMA 1227.
Alleged contemner.
1227.
Why have you violated, Mr. Banerjee? Why have you violated the order?
At the outset, Lord, I am tendering unqualified apology on behalf of alleged contemner. But Lord, your Lordship kindly see, where earlier Mr. Diptendra and Banerjee submitted report. Your Lordship was not satisfied. That's why, Lord, I called the DI. And Lord, this is the
Now it has been complied.
complied is already, Lord. But Lord, secretary, Lord, he also ought to have been Lord, made as a contemner. Because
Kindly see the last paragraph.
yes. Last pursuant to these orders, the secretary so is requested to take necessary steps for the joining of the petition at the said madrasa and release of salaries as well as other benefits subject to the result. Yes,
Now, when your lordship pass this order, kindly see.
yes, your lordship has said.
Joining of the petitioner at the madrasa and release of the salary,
Yeah.
as well as other benefits subject to the result of the
Because your lordship has granted liberty that in accordance with law.
No, when your
department
lordship pass
proceeding
this order,
content-
kindly see.
the time.
My lord, this order was for 5th September. No, the letter was issued on 15th
I have
January
tendered unqualified apology for this.
2025. 3 months, my lord.
Mr. Banerjee, you have
My lord,
not
that's
be-
why, my lord,
because the person, why a contempt application has to be filed?
my lord. Absolutely, my lord. Being an officer of the court, my lord, I will.
I have lost 3 months.
Because
I have lost 3 months.
I had called the Lord the DI here, and Lord, I said him, you don't do this.
But the only thing will be,
But the secretary,
have you joined?
Yes, I have joined 17th January. You lost
He will be
benefit-
saying,
no.
because of this delay, I have suffered for some months.
No, my
That's
lord,
why.
already consequential benefits. He will get all the benefits.
No, 3 months I have lost.
No, 3 months. My lord,
October, December.
I'll tell them 3 months benefits he will give. Lord, your lordship kindly not record. Lord,
Then, Mr. Banerjee, don't make that submission. You come with the instruction in writing. So I will take it on record. Don't make those submissions.
I had a talk. That's why, Lord, I'm saying.
That is why I'm keeping it in the next week. Because don't make the, because you are representing an
Kindly
authority.
keep
I'm
this.
recording this.
Your lordship can not only not subject to correction. Your lordship can dispose it of. But with the observation, since he has already suffered for the likeness of the contempt, that period should be taken into consideration. Lord, thereafter I will tell them. Oh, don't.
But salary I have not received as yet.
Salary?
I have not received as yet.
No, that 15th of January, 17th of January, you have just joined. So I think 1 month also you have not worked.
And your
So-
lordship has said consequential benefits. That's why
Yes,
Lord,
yes.
it covers all.
The order was dated 5th of September.
September 2020.
This is an application alleging violation of the order dated 5th of September 2024 passed in WPA 589 of 2024. First up, Mr. Banerjee, learned advocate appearing for the alleged contemner, submits that the order and directions contained in the said order has already been complied with. First up, he places on record.
Now,
He
your lordship
places,
kindly record, Lord, I have tendered apology, Lord, for the delay in compliance.
he places a memo number 19/LS dated 15th of January 2025 in support of his contention that the said order dated 5th of September 2024 has been complied with. First up, in the said memo, it has been stated as follows, বলে না এইটুকু এইখান থেকে এইটা রেকর্ড করে দেবেন। আচ্ছা, ওটা টেকেন অন রেকর্ডটা বলেছি, let the said memo is taken on record. First up, Mr. Banerjee, learned advocate appearing for the alleged contemner, tenders an apology for delayed compliance of the said order. Such apology is accepted. Now, the apology tendered by the alleged contemner through Mr. Banerjee is accepted. First up, Mr. Dotto, learned advocate appearing for the petitioner, submits that due to the delayed compliance of
Already
the
joined, your lordship, he has said already joined, your lordship.
আচ্ছা তার আগে লিখুন Mr. Dotto, learned advocate appearing for the petitioner, submits that pursuant to the said memo dated 15th of January 2025, the petitioner has joined the
17th.
said madrasa on 17th of January 2025. Mr. Dotto further contends that due to the delayed compliance of the said order, the petitioner has suffered as he could join only on 17th of January 2025, though the order was passed on 5th of September. 5th of September.
Fifth of September 2024. 5th
But,
of September
5th of
September
September. But
2024.
Mr. Banerjee, kindly come to the second paragraph, first line.
The
Oh,
petitioner
5th of, both the orders were under challenge. All right. Though the order was passed long back, that is on 5th of September 2024. Full stop. Faced with such submission, Mr. Banerjee, learned advocate appearing for the alleged contemner, submits that necessary steps will be taken to ensure that the petitioner shall not suffer for the delayed compliance of the aforesaid order. Such submission of Mr. Banerjee is placed on record. With the above observations and directions, the contempt application stands disposed of. You have got a copy of this. You must have, because you have joined.
Since I am here, I will convey.
Because otherwise it could have been, because this is the
I
question
know
of.
your lordship, your lordship also knows. But I will communicate and
Yes, call the
I'm
next matter.
ensuring my learned friend. আমার পিছু ছাড়বে না ভাই তুমি চলো এবার চলো তো
Yes, call the next matter.
other matters, my lord, I have said your lord, junior, yeah, we have read Parusuram and Sisholola, then Guru and Sisholola.
Yes, call the next matter.
My lord, short point involved here, my lord.
Mr. Wasim members for the state.
My lord, the first time it is
Wasim
appeared.
members for the
I have
state.
not served, my lord.
You have not?
Sir, first
Oh,
time.
this is the contempt application.
Contempt,
First time,
first
yes.
time.
I do not have a copy of this.
My lord, what happened here, my lord? There was a forced
You
deed.
have instructions to appear for whom? The alleged contemner.
My lord, we were for the state, my lord.
State, it's a contempt
I'm
application.
not sure, but once I have the copy in hand,
You have instructions to represent the alleged contemner.
I do not have any.
Then don't appear.
Notice হয়নি তো admit হয়নি আমার application.
If you say you have instructions to appear for the alleged contemner, then I can.
My lord, what happened there?
What was the direction?
My lord, direction was there in that is page 14, my lord.
Page 14.
14. What happened here, my lord? There was some forced deed. In issue of that, my lord, civil suit is going on. And my lord, the one complaint was filed and ultimately, my lord, the investigation was registered. But that was not, my lord, going in a, my lord, in a fair manner. That's why my lord was pleased to direct in view of the thereof, the writ petition is disposed of directing the investigating officer to conclude the investigation expeditiously. Thereafter, neither those deeds were seized. Nothing has been happened. No step.
Can it be a ground for contempt?
My lord, kindly direct to serve copy. My
So
lord.
I have next paragraph.
Next paragraph,
If
yes.
you are not satisfied with the investigation, take appropriate steps. Contempt is not the.
My lord, with the deepest respect, subject to lordship kind sanction. My lord, this part comes, my lord, after filing of charge sheet. If my lord charge sheet is not filed properly, my lord, I can agitate before the magistrate.
Even investigation, if it is not properly, investigation is not done.
My lord,
You have remedies.
my lord, with the deepest respect, my lord, the investigation is not monitored by the learned magistrate. Therefore, my lord, what my lord was.
You cannot approach being dissatisfied with the investigation.
My lord, then I have to file a fresh writ application, my lord.
Fresh?
Writ application, my lord,
No,
regarding the
no provision is there under the BNS.
168, my lord, says otherwise, my lord. After filing of charge sheet, I can agitate. This section is not applicable. This is the material you have not annexed. But in midway, my lord, I have no access with the investigation. Therefore, what my submission before your lordship, my lord, kindly, my lord, take to conclude the investigation. Whether my lord was pleased to.
What is the direction? That was the direction. Conclude the investigation expeditiously. Court cannot fix a time limit for investigation.
My lord, from September, my lord, we have 6 months gone, and that investigation.
It's difficult to fix a time limit. That is why no time limit has been fixed.
My lord,
that is the difficulty.
My lord, direct to serve a notice, it will serve the purpose, my lord. They will file the notice. If the notice will serve the purpose.
Because we are repeatedly, my lord, wrote a letter, communicated, but they are not giving.
Petitioner is directed to serve a copy of this application upon the alleged contemner and file an affidavit of service on the next date. List this matter under the same heading after 4 weeks.
Grateful, my lord. Well, this notice will serve all right.
Yes, next.
May it please your lordship, my lord, I am for the petitioner.
20.
My lord, I am for the petitioner led by Mr. Vivekananda Tripathi. My lord, Mr. Tripathi is suffering from pox. That is why he is not able to come, my lord. However, I have
This is
been.
the contempt application.
Yes,
First
my lord.
time you serve.
My lord, this is an excruciating saga of the petitioner, my lord. She is a 98-year-old lady, bedridden lady, my lord, 98-year-old. And your lordship was pleased to direct the payment of family pension on 8th of August 2024, my lord. And considering the gravity of the situation, my lord, I am praying for a rule to be issued, my lord. Still, it hasn't been done. 98-year-old lady,
So
my
I'm
lord.
directing you to serve a copy of this application.
Very well, my lord.
This is an application alleging. This is an application alleging. This is an application for contempt alleging willful and deliberate violation of the order dated 8th of August 2024, passed in WPA 513 of 2020. First up, the learned advocate appearing for the petitioner submits that the said order was duly communicated to the alleged contemner, but till date, no steps have been taken by the alleged contemners in terms of the order dated 8th of August 2024. Petitioner is directed to serve a copy of this application along with all the annexures upon the alleged contemners by speed post with acknowledgement due and file an affidavit of service on the next date after 4 weeks under the same heading. This matter after 4 weeks under the same heading. Yes, next.
Grateful.
23.
Appearing for the petitioner, this is the first time today.
Answering respondent is the state.
Well, not only that, the school, both state and the school, because Roshis
Who
kindly
appeared for the state?
earlier.
Yes, yes.
Mr.
Pontu
Pantu
Dev
Dev
Roy
Roy.
and Mr. Shambhunath Roy for the school. What was the direction?
Roshis kindly come to page 83.
Oh, that was the cook. Stealing of eggs.
Yes, my lord. My lord, and the order was set aside. And my lord, they school preferred an appeal that was also dismissed as withdrawn because the school preferred an appeal with all the state respondents as appellant without having any vocalatnama. So that was also withdrawn. And all are saying now, state and school both, that we are complying with the order. The first stage of compliance is when the order is set aside, you have to allow the petitioner to join. The petitioner wrote letters also to that extent. But
all right, this is an application for contempt alleging willful and deliberate violation of the order dated 8th of March 2024, passed in WPA 23646 of 1997. First up, Ms. Sengupta, learned advocate appearing for the petitioner, submits that the said order has been duly communicated to the alleged contemners. She further submits that an appeal was preferred by the school authorities against the said order, which stood dismissed as withdrawn. First up, she further submits that paragraph. The petitioner is directed to serve a copy of this application upon the alleged contemners by speed post with acknowledgement due and file an affidavit of service on the next date. In addition, the petitioner will be at liberty to serve the learned advocates who represented the state and the school authorities in the writ petition. First up, let affidavit of service showing compliance of this order be filed on the next date.
Only
4 weeks.
3 weeks. 3 weeks. Well, I shall do everything in the meantime.
4 weeks, let them. Sometime you have said that they have not
but
done.
The
some
difficulty
time
is
is
that in the end of January, the petitioner's retiring age is coming.
End of January, it cannot be helped.
That is
We
why
have
we serve
come
so
at
many
the
letters
fag
upon
end
them.
of January.
Yes, my lord, that's true. No, we served so many letters upon them, and also the appeal was pending, so we could not
So in
take any
any
contempt.
case, nothing can be done before January.
Well, only on liberty I'm praying that in the contempt application, I stated that we made application under Right to Information Act upon the state, going to know that what they are doing regarding this case. Now, my lord, the reply we got subsequently, so I'm praying to file it by
Supplementary
supplementary.
affidavit filed in court today, as prayed for by Ms. Sengupta, leave is granted to the petitioner to file a supplementary affidavit. The supplementary affidavit filed in court today is taken on record. এটা না একদম উপরে করে দেবেন। আর যেখানে ওই সার্ভিসটা বললাম না সেখানে contempt application as well as the supplementary affidavit ওইখানে একটা insert করে দেবেন।
My lord, by 3 weeks we can do it. We can do it by 2 weeks. But my lord, if my lord so thinks,
Sometime you serve a copy upon the learned advocates who represented them. I think if
that will-
anything is
but my lord, before the returnable date, they will not come and submit. So returnable date be sooner.
you
shall
may
serve
not get any instruction. Your client will get some instruction prior to that.
Grateful, my lord, grateful.
Yes, next.
24,
Pass over next.
25,
25, my lord, I was appearing for the state, my lord.
Mr. Bandyopadhyay, data entry operator.
No, my data entry operator is 3435, item number. So this is land acquisition, which was not concluded. Mr. Pan was appearing for the petitioner.
Oh, that direct purchase policy.
Yes, yes. So your lordship has recorded that I have prayed for 6 months' time, my lord, to complete it. My lord, your lordship may keep it, my lord, a fortnight hence, my lord. We are already taking steps, my lord. We have ascertained the market value of it.
Where is Mr. Pan? একটা সময় যদি কিছু আর্জেন্ট থাকে না হলে Yes.
Well, kindly takes the last order, my lord. Your lordship recorded my prayer and kept it today, my lord. We are taking steps. We have ascertained the market value. My lord, may keep it after a fortnight, my lord. We can come back with better particulars, my lord.
None appears for the petitioner. At the time of call, Mr. Bandyopadhyay, learned senior standing counsel, submits, prays for a further time of 2 weeks to revert to apprise this court of the further developments in this matter. As prayed for by Mr. Bandyopadhyay, lists this matter under the same heading. After 2 weeks.
My lord.
Yes, call the next matter. Next is also same.
My lord,
26 and 27.
26, my lord, as per your lordship's direction, the affidavit has been affirmed. 26 and 27.
Who is appearing, Mr. Amit Pan?
Yes, yes.
Where is he?
He is not rushing today.
What is the affidavit that you are ready and willing to
Yes.
proceed as per the direct land purchase policy?
Yes, your lordship was pleased to ask the time limit to payment.
Give me the, as well as your willingness also.
Yes, yes. Sir.
Show me the affidavit.
It 26.
Have you served a copy of this affidavit
Yes,
upon
yes,
the
yes.
petitioner?
17. I have served 15 affirm and 17 served.
No, this is which item? 26.
Sharat Chandra Mondal. Page number 4, my lord.
None appears for the petitioner at the time of call. Uska paragraph. The learned advocate appearing for the state files a report in the form of an affidavit, which is taken on record. Let a copy of such report be served upon the learned advocate for the petitioner in course of this day.
Yeah, I have already been served on
You have,
17.
you have served. Oh, achha. The learned advocate appearing for the state submits that a copy of such report has already been served upon the learned advocate for the petitioner. List this matter in the next week under the same heading. Next.
27 is also same.
Eta কত?
27.
27. এটা কোথায়? এটা হচ্ছে পূর্ণিমা মণ্ডল।
পরের এফিডেভিটটা দিলাম
পূর্ণিমা মণ্ডল 27, ওটা 26, এটা 27। Yes, you are filing same order. Report filed by the respondent. You have served a copy upon this. একই।
This is the enrollment.
Yes, call the next matter.
Deeply obliged.
28.
In this matter, an application for vacating of the interim order has been
Has been?
filed.
Yes.
For the Balurghat municipality, led by Mr. Srijan Naik.
Who has filed?
Filed by Bonga.
Where is Bonga?
Mr. Sayon Sinha.
Today you are on holiday, Mr. Banerjee.
Yes, yes.
Mr.
Should have been declared.
Not today?
What? This is the 5th attempt today. Unsuccessful attempt.
You are responsible for that.
Yes, yes.
Not
Whatever bad thing in this High Court,
No, not bad thing. Not today. Any recording will help you, Mr.
for petitioner, no help.
Not today. Next. আচ্ছা একটা লাইন অ্যাড করে দিন। Mr. Basu, learned senior advocate, appears for the petitioner. So he submits that an application for vacating the interim order has been served upon him. None appears for the Bonga municipality, which has taken out an application for vacating the interim order. Bonga has taken out. Since the Bonga municipality is not represented, this matter in the next week under the same heading. Next.
Lordship, Balurghat municipality is represented.
Balurghat municipality is represented. Give your appearances.
Lordship, grateful.
Next.
29.
Lordship, in this matter, hearing was concluded by.
Where is Mr. Chatterjee?
Mr. Chatterjee is no. Mr. Chatterjee is not here, Lordship. Your Lordship directed to file.
He has not come to court.
Your Lordship,
Madam, what is your reaction to this judgment?
Lordship, in this matter, Mr. Orkodipto Sengupta is appearing on with
Where is Mr. Sengupta?
He is also not come. Then Lordship, kindly take this matter on Monday.
I have asked him whether he has undertaken this research. This is a judgment on that point. Nobody has cited this.
Lordship, then kindly take this matter on Monday.
Lordship, I am led by my
As per Mr. Chatterjee's direction, I want
Repeat with you. Don't file today. Consider this judgment.
Lordship.
Ashun. This matter was adjourned to enable the learned advocates of the respective parties to file their written notes of argument. First up, the learned advocate appearing for the petitioner. Attention of the learned advocates for the parties was drawn to an order, drawn to a judgment and order passed by the Honorable High Court at Jammu and Kashmir at Ladakh on 6th of October 2023 in SWP number 2532/2002. First up, the learned advocates for the respective parties seeks an accommodation to consider the said judgment and revert back to the court on the next occasion. Monday, madam.
Monday, Lordship.
Your Lordship, I am led by my senior Ajit Kumar Chaube. Due to personal difficulty, he won't be here. I'm kindly praying to keep it after 5th, if your Lordship allow.
I could not hear you.
I'm saying, Lordship, I'm led by my senior Ajit Kumar Chaube. Due to personal difficulty in his family, he's out of station. He would.
When he will come?
Anytime after 6th. Whenever your Lordship.
After
6th of February, because there is a demise in his family.
6th of February. Who is assisting Mr. Chaube?
Mr. Saurav Mandal. Saurav Mandal.
Ask him to be present.
Okay, Lordship.
Monday.
Lordship.
List this matter under the same heading.
Monday.
Next Monday. Don't file the written notes.
No, Lordship.
Keep it with you. Consider this judgment.
Judgment.
Grateful, Lordship.
This is the direct answer to the points raised. Yes, next.
30.
On item 30, my lord, I appear for the petitioner. Mr. Chandrachu Chatterjee is assisting.
I'm praying for. I'm led by Mr. Mujumdar in this matter.
You are led by Mr.
Abratosh
My
Mujumdar.
lord, I am appearing in this matter with Mr. Chatterjee.
Yes, Mr. Mujumdar.
My lord, I was making submissions, your lordship may recollect, subject to lordship's kind consideration, where the board of directors.
My lord, I'm appearing for the private respondent. My senior hasn't come to the court today. I'm praying.
Does not come to court. Who is your senior?
Mr.
Mr. Banerjee, I believe.
Mr. Siddhartha Banerjee. He has not come to court. Mr. Mujumdar.
It's a deemed holiday, my lord, what we can do.
All right.
My lord, only one submission before your lordship, subject to your lordship kind consideration. My lord, Mr. Chatterjee, my junior, would be in a difficult position. He will be out of station till Tuesday, subject to correction by Mr. Chatterjee.
Wednesday.
So, my lord, kindly keep it after Wednesday. My lord, let the matter retain its position. We have been trying hard to get this matter heard before your lordship. Kindly, my lord, subject to
When do
lordship.
you want? 30th?
Yes, 30th. 30th. Mr. Chatterjee is here.
30th.
So grateful.
Mr. Mujumdar, learned senior advocate, appears for the petitioner. First up, Mr. Royal, learned senior advocate, is representing the state. First up, an accommodation has been prayed for on the ground of Mr. Banerjee, learned counsel, representing the respondent numbers 6 to 17. First up, as jointly prayed by the learned advocates for the parties, the list this matter on January 30, 2025 under the same heading.
Grateful, man. Grateful.
Next.
One.
My lord, in item number 31, Mr.
31, I am for the school.
Lord, the petitioner, my lord.
Who is appearing?
Mr.
I'm
Shukanta
for-
Chakraborty.
Mr.
Shukanta Chakraborty. My lord,
Shukanta
due to some
Chakraborty.
difficulty, he is not available
It
today.
is which matter?
In
Private school.
Yes, my
Disciplinary
lord.
proceeding.
Exactly, my lord.
How the writ is maintainable?
My lord, you have fixed it.
Where is Mr. Chakraborty?
Due to some difficulty, he is not available today, my lord.
He has not come.
No, my lord.
Monday. Not today. Next.
My lord, item 32, my lord, I am for the petition.
32, yes.
My lord, I am led by Mr. Shoktinath Mukherjee, my lord, appearing on the virtual mode.
Who is
May it please
opposing?
your lordship. I appear for the respondent number 10. I am being led by Mr. Roslanka Banerjee. Yes, yes. Sorry.
Therefore, respondent number 10.
Yes.
May it please the lordship, I beg
Yes,
we appear on.
who is for this state?
My lord, Mr. L.M. Mahato was appearing.
State is not here. Mr. Lolit Mohan Mahato.
My lord, my lord.
My lord, may
Mr. Mukherjee, the state is not here.
kindly post it on some other day according to your lordship's convenience.
Yes, you are appearing for?
Respondent number 10.
Respondent
Led by
number
Mr.
10.
Roslanka Banerjee.
Lord, I am for 10, my lord.
10 dekhiye.
Yes, Mr. De, you are appearing in this matter.
31.
32, you are not appearing.
My lord, I have just sent the junior to inform Mr. Mahato.
You have sent the junior. So, I am keeping it at 2 p.m.
Some
Not today then.
Convenient for all of you.
So,
Or
I think
Monday.
Kindly make it on some other day instead of 2 p.m.
Or like Monday.
Monday.
Some make it only not today.
Yes. Yes.
Mr. Banerjee, Monday you had some problem. That is
No,
what
it's all right, Mr. Banerjee.
Okay, okay, okay.
Yes. Next.
33.
Your lordship, I am appearing on behalf of respondent numbers 4 to 7. My learned senior in the matter is not available. I am kindly praying for an adjournment.
In all matters, the advocates are not present. Mr. Majumdar, what can be done?
This is a contentious matter, not that pay fixation.
The respondent. Oh, this is the other matter which you have started. Monday? So I'm making it not today only? Not today, next. What are these applications for?
Some of them have been disposed of.
No, I think one application is in the list. Can see what key ache dekho
There
to?
were applications not permitting the employees to get their pensionary dues settled with that reduction of increments received at one point of time. So at the reduced stage, they received the pensionary benefits subject to the result of the writ petition without preserving their rights in the writ petition.
But why it is pending?
It should have been disposed of.
দেখুন তো can 3টা কি pending? Appropriate order. এটা কি pending? Order sheet-টা? It was for appropriate order. Seven two nine eight.
There is an application for early hearing.
This is for early hearing. No, 7298. For appropriate order, it has been styled.
7298 is an application for vacating the interim order. And to fix provisional condition. This is at the instance of the employer.
This is at the instance of the employer. Then
She is finally hearing out the matter. So this vacating
they are
application.
not here today. They may say that
Can
because
10101 is also a modification application. But these are all.
no, I find from the list only this application is pending. Can 3 of 2019.
That's probably because Mr. Mukherjee, Prabal Mukherjee said on the last occasion that let this application be disposed of along with the writ petition.
So let it appear. Yes. Call the next matter.
Thirty-four.
34 and 35 are the analogous matter, Your Lordship. On the last occasions, the state has concluded their submission, Your Lordship. So, Your Lordship, I'm praying for a short one-day accommodation, Your Lordship. Since, Your Lordship, I'm led by Mr.
As prayed for by the learned advocate for the petitioner. The hearing of the, you are for the petitioner?
Yes, Your Lordship. In both the matter, Your Lordship.
The hearing of the matter stands adjourned for this day.
Grateful.
Yes, next. Yes, call the next matter.
36.
Pass over. Next.
37.
I appear for the respondent KMDA led by the learned advocate general.
This is that matter where you are led by the learned advocate general. He is ready.
That
is Act 2.
I didn't
Act
get
2 of 1948.
Suddenly today.
Then I can take it up. Otherwise, no use.
My lord,
It is again
better make it not today, my lord. Today I'm not sure that he will be coming.
Then Monday, I'm fixing it.
Monday.
Yes. Why?
Very short matter, my lord. It was
Mr.
decided
Banerjee is
up to
saying very
Supreme
short
Court.
matter.
They up to decided up to Supreme Court, and they are always taking adjournments.
Act 2 of 48.
Act 2 of 1948.
What happened? 4-1A initiated.
4-1A initiated.
Thereafter,
3 years after 3
not
years.
carried forward by 9-3 and 9-3B.
Right.
Then
they are retaining possession. We file a writ petition for the purpose
in the meantime, 1997 Act repeat.
1997 gone.
2013 Act
94 gone. Everything gone. Nothing remains.
So now 2013 Act.
Yes.
Now your submission will be direct land purchase.
And not only that, I have.
So
Lord, I have.
They are not entitled to.
Lord, I have. And not only that, my lord. That is a total notification, 4-1A notification, and 3 notification at a time. Maybe that can be done. Lord, now half of the property belonging to my client and half of the property belonging to X.
Oh yes.
X filed a writ petition. X filed a writ petition with regard to that notification. Lord,
notification was set aside.
Yes, that was lapsed. No, lapsed, and it gone to the Supreme Court. Supreme Court SLP dismissed.
No, what lapsed? 4-1A stood lapsed.
4-1A stood lapsed. No notice under 3B, 9-3B.
If 4-1A stood lapsed, 9-3B could not have been resorted to.
Yes.
9-3B.
If 4-1A, Lord, that is my.
There is a valid 4-1A.
Lord, that is my argument always, my lord. That if 4-1A is lapsed, then question of
9-3B does not
question of
arise.
continuation of the proceeding under the Land Acquisition Act and by giving notice under the State Amendment Act under Section 9-3B.
It would have been 9-3A.
Yes.
But not 9-3B.
Not 9-3B. Lord, that is my opinion, subject to my lord's acceptance. That is my opinion, my lord.
First of all, he has to pass.
No, 9-3B presupposes a 4-1A.
4-1A.
That would be the starting point or the calculation of the valuation.
Exactly
Valuation
so,
will be
provided.
So there
Yes.
has to be an existence.
Provided,
4-1A.
right, my lord, provided 4-1A is not lapsed. If lapsed, then he can under Section
So it uses the
9-3B.
expression issuance of 4-1A.
Yes.
But if 4-1A should lapse on a point of
then
time,
everything gone.
9-3B.
Everything gone.
Before coming to that,
you can start.
He has to pass the hurdle. He has to
Talukdar,
pass
you
the
can start
hurdle.
now.
Mr.
Pass the
Talukdar, you have
hurdle.
to conclude.
He is a
Mr.
subsequent
Banerjee has
transferee. He
in
is
a way has
in all respect.
made his
whether
point.
he can, my lord, take that benefit, my lord. He has to pass that hurdle first. He is a subsequent purchaser.
Oh,
Mr.
But this
Talukdar,
is-
Whether
Have
he
you-
can at all
I
challenge.
can
taken
answer.
possession of his land. Have you taken possession of his land? Under what provision of law?
Act 2.
Act 2,
Act 2.
Section 3(1). After that, what did you do?
4-1 issued.
4-1A. Show me the award. Show me
Award,
the award.
award declared.
When have you declared the award?
2006.
When 4-1A was issued, what is the date of the award?
Yes.
Show me that.
Yes.
End of the matter.
Show me.
We'll argue that.
These are the factual part.
We'll argue on that.
What argument? You are saying 4-1 and award. Give me these 2 dates.
Lord,
End of
award-
the matter.
award,
What
my lord-
argument? It
Lord,
does not
award
require
was
any
annexed.
further argument.
My lord,
If you have paid, Mr. Banerjee's client do not have any further right.
Yes.
If you have paid
we have
within time limit of section 7 capital A.
Yes.
here Act 2 proceeding could not be completed within time. It was switched to Act 1.
Yes. So do not say that the award was declared in accordance with 7A. Don't
Not
say that.
7A. We are not claiming also.
So it was carried forward
Carried forward.
under Amendment Act 1997 by resorting to what provision?
Right.
Yes.
93A or 93B?
There's the question to be decided.
I'm asking
Here,
you.
here,
No, I'm asking you on
according
facts.
to us, Milord,
On facts.
amended provision of 9 was resorted to.
Only 9.
Yes.
That argument was advanced before the division bench.
And this petitioner is trying to take shelter of that judgment.
No, forget about that. It will be decided independently.
Yes.
I will not take into consideration that judgment.
Yes.
Yes, you can argue.
Yes.
I will not
Let him argue.
rely upon that judgment.
Yes.
I will not allow Mr. Banerjee to
Lord,
place reliance on that judgment. You can independently argue this matter.
We'll argue on that.
Start.
Not
Mr. Advocate General will
just
join you. Mr. Advocate General will join you.
It would not be proper for me to start.
These are the 2 dates, Mr. Talukdar. 4-1A, then section
He-
9,
He has.
then when award was passed.
Lord, we have something more to submit, my lord. He will make submission.
What more? Kindly
What
tell
more?
me that. What more?
What is the point of law you want to argue?
No, first of all, subsequent purchaser whether can challenge this proceeding, that is to be decided. Whether at the instance of this petitioner who has admittedly
purchased
2000, 2002,
2002.
After lapse.
Mr. Banerjee, take your seat. When 4-1A was issued?
long before.
89.
I'm asking you.
89. 89.
So whether it was valid on March of 1997?
If it is switched to Act 1, then
Could
it
not
is
have
really-
switched to Act 1 prior to 1997? Could not have switched to prior to 1997 because that amendment came in 1997.
My lord, is speaking
So-
to application of 7A. It's application of 7A.
So if there was no valid existence of 4-1A, so the provision of vesting goes. That was under 4-1A. 4-1A talks of vesting, lapsing, vesting goes, divested are decided in one matter. I think you are counsel in that matter, party to that. So vesting, divesting of the property reverts back in that matter also. I think the learned Advocate General was leading you in that matter also. That is the point of subsequent purchaser that also went against you.
That is now pending in appeal.
The party's name will not behind because it is not reported. That is the whole difficulty.
Which?
That is your lordship judgment.
That is under appeal.
He's saying under appeal.
Maybe, but I want to know, we are a perpetual learner in this. profession.
Let us argue that.
We always want to learn.
The Talukdar appeared.
Can he
I do not
prevent me to
recollect
learn?
the
Can he
first
prevent me to
article,
learn?
but KMDA is also a part. Give him the judgment.
Let us start. Let us start.
No, he will start, but give him the copy of their judgment.
Prior to, let us start. Let us start. My lord knows that. He will be knowing that also.
He will be?
You will be knowing that also.
না না ওটা জানি না উনি যে জাজমেন্টটা অন্য একটা জাজমেন্ট ওটা পাই
But here the facts are different.
Maybe I want to look into that.
And the grounds taken in this writ petition are also different.
All right.
Ashun.
Lord, what I do not know, candidly, my Lord, I confess to the before the Honorable Court, I do not know. Even before a junior, kindly give me
Mr.
that.
Banerjee, this,
Because we are a
this was
perpetual
an issue
learner in
which,
this
which
profession.
cropped up because in one of the matters, I tell you, I dictated a judgment in open court.
Lordship.
Thereafter, it struck me. I recalled, I heard it again, and I have delivered a judgment.
Lordship.
Thereafter.
Lordship.
Because this point struck me.
Lordship.
When I was about to sign.
Lordship.
None of them raised, but it struck me. Then I recalled that. Suo moto, I've asked the learned advocates to re-argue the matter, and after that, I've delivered.
Delivered, yes.
So this was the issue whether this 9(3)(b) could have been resorted to if there was no valid 4(1)(a) as
Yes.
on that date.
No valid, yes.
And then also the vesting also goes.
Yes. Vesting also goes.
So vesting is a consequence of 4(1)(a).
4(1)(a).
So here is the difference between 1894 and Act 2 of 48.
That's right.
Because they are after payment, then possession, vesting.
Yes.
Here
Under
is
section 16.
Yes, here is with 4(1)(a) vesting.
Vesting.
Payment thereafter.
Lordship. And under section 16, my Lord, title is with the owner unless compensation is paid.
Yes. So there after award, thereafter possession,
Yes.
vesting.
Therefore, there is a gulf of difference between the two acts.
Yes.
Lord, that I wanted to argue that.
That Supreme Court judgment was cited by the learned advocate general in
Yes.
that matter. I've
Yes.
considered that, and I've
that Supreme
delivered
Court
the judgment on
for
that.
vesting transfer, he has got
Because
the right.
according to them, once vested cannot be divested.
Cannot be divested.
That I've clarified that.
That's right. Lord, exactly that I want to argue that without knowing your Lordship judgment. The distinction between that Act 2 and Act 1. Act 1 in the case of 16, Act 2 4(1)(a) vesting.
And the effect of lapsing.
And effect of lapsing. And once the notice is lapsed, there is no longer. And they do not want to continue by adopting the procedure under 3B, then 3A, even after that, during the validity period.
3B, 4(1)(a), the valuation will be at an earlier point of time.
Right.
9(3)(a) will be as on the date of issuance of that.
Right.
That will be a subsequent, so the valuation market value
Right.
will be.
Right, my
with
Lord,
effect from a
absolutely, that is right. That is my argument. I have brought it, my Lord. But your Lordship judgment, my Lord, I wait to, hey, তুমি ওটা দিয়ে দাও, ওটা দিয়ে দাও। না 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 রেফারেন্সটা দাও না খালি আমি বার করে নেবো।
Yes, call the next করুন order record করে দিন। Mr. Banerjee, learned senior counsel, appears for the petitioner. Mr. Talukdar, learned advocate, appears for the KMDA and seeks an accommodation on the ground of the learned advocate general. First up, paragraph. As paid for by Mr. Talukdar, list this matter on Monday under the same heading. Yes, I think this is that matter where the learned advocate general took some time to go through the schedule of the plots of land.
Yes.
This matter.
Lord, that is why I have taken the certified copy of the earlier matter. Lord, that X matter, half portion, taken a certified copy identical, so that I can show the notification and our notification. From the certified copy itself, it will appear. I know that this controversy may arise. That is why I brought it.
On which he is relying, that roomta is insisting.
Roomta, half portion, Lord, property released in favor of.
Even without going to that.
Even without going through that.
Talukdar, you have to show.
In view of Godfrey's judgment, my lord, he cannot. That is.
Maybe, but even without that, whether you can.
What my lord has already decided, and here also we will argue that whether vesting can be.
If the same point is in issue, I can.
I cannot say that.
Refer this matter to be tagged with that appeal. Mr. Banerjee, I think that's better.
It will depend on
No.
the advocate general.
But
What
your
you will
Lordship
argue,
knows, my Lord, your Lordship knows, my Lord, the judgment of the Supreme Court, so long as the single bench judgment will operate even if appeal is preferred. Because division bench justice.
It operates inter partes even if it is stayed.
Even if
The
it is
binding
a
effect of the judgment
lordship.
is not lost.
Lordship.
Yes, but instead of that,
And 91 Supreme
this
Court
matter
law.
can be referred to the division bench to be heard along with that appeal.
Question of reference, my lord, there will be a difficulty on our part. Anyway, let him argue on that.
On that particular
You
point,
can argue the legal points there, Mr.
Yes,
Banerjee.
yes.
if vesting goes, then getting of judgment right up to the Indo Development Authorities.
Indo Development
that
Authority is
settled
under
proposition.
Indo Development Authority, can you
Act
take
1.
help of that
No,
in this matter?
particularly
Under Act 1.
24(1)(a).
No, not on. I am not on that. That once vested, it
That
can't
is
be
on
divested.
24(1)(a).
This
on-
is reiterated in the Indo
Yes,
Development
yes.
Authority also.
That was done considering Act 1, where the proceeding for vesting is after all, after payment, after award.
But here the vesting in Article Act 2, my lord knows that vesting.
4(1)(a).
Yes, 4(1)(a).
4(1)(a), if it is lapsed, can you still say yes, stood vested?
Here
And you can continue eternally without paying compensation.
compensation.
That will be
the
because
method,
you have
mode of
become the owner.
compensation will be maybe different.
Talukdar, if it has stood vested, you will become the owner. You will say, yes, I will not pay compensation. It is my property now.
My lord, I am not arguing this case. Just to answer it, my lord, to my little understanding, my lord, after vesting is done.
That was the object of introduction of 7(a). Because earlier there was no time limit. 7(a) of Act 2. Am I right, Mr. Banerjee? That was the object behind introduction of 7(a).
And that was not there earlier, my lord.
There was no time
Notice-
limit. There was no time limit fixed for passing of the award. Then 7(a) was introduced.
Here, my lord, the notice shall lapse. That is 4(1) shall lapse. If that
But
lapse,
vesting will not revert. That was argued. I have decided that. Try before the
in my understanding, my lord, the method of mode of my lord, calculation of compensation may be different. Because if 4(1)(a) is valid, then
তাহলে
three
argument
lies.
করে দাও না আজকে
Then
argument করে দাও না এখনই দিয়ে দিচ্ছি argument করে দাও না
Yes, Mr. Talukdar is ready with this.
very very
Yes.
well,
all the
nice
next matter.
gentleman very nice gentleman এই করে দাও সম্ভব তুমি দিয়ে দিও আমাকে
Call the next matter.
get full
74.
My lord, Mr. Devabroto Acharya is appearing for the petition. My lord, he is temporarily indisposed of, my lord, running fever. My
My lord, I appear for
lord, pays for time.
PMDA. I am not the principal respondent here.
You are not the principal and you are led by
No, here.
not the Advocate General in this matter.
No,
The other matter also, you are not the principal respondent. I could have proceeded, Mr. Talukdar, ignoring
my lord is not
who is
required,
leading you in that matter.
but it is
There
the
you are from
state
the
is
requiring body. You are saying, yes, I have a right.
I didn't say that we are the principal respondent.
Yes.
Well, it is against the state. The state's purchase policy is under challenge.
State's purchase policy. But you are the requiring body.
No, we are not the requiring.
You are not the requiring. Why KMD as a party then?
I do not know, my lord, why.
All right. Not today. Next.
My lord, 75, I beg to appear on behalf of the petitioner, man. I'm
Yes.
sorry I had to appear online because of my personal difficulty, my lord. My
Yes.
lord, the issue here in this writ petition is with regard to I have challenged the entire disciplinary proceeding which was initiated against me in the year 2017 and culminated into the order of dismissal. My lord, the primary ground of challenge of this writ, in this writ petition is that the procedure as well as from the minutes of the proceedings, it will be evident that the inquiring authority completely acted under the dictation of the disciplinary authority, in spite of the fact it is well settled that an inquiring authority in a disciplinary proceeding has to apply its own mind and has to pass a proper order. Inquiring authority, my lord, it will be evident. My lord, I find that there is no respondent.
No, there is no one for the bank.
Bank, my lord. It is only the bank. On the last occasion, the bank appeared and they submitted one judgment. They referred to one judgment, not submitted, my lord, wherein they said that similar issue has already been decided by my lord. My lord, I have gone through that. I will also rely on that judgment, which because I find them to be in my favor also to some extent. My lord, my lord?
Then I'm making it adjourning it because no one is there for the bank today.
Yes, ma'am. My lord, I just beseech you, my lord, can it be on Monday? If the date is mentioned, I believe my lord will take it up on Monday itself. Well, it will be either I have to succeed or succeed in the point, because my lord judgment is all there. I have to show the judgment along with the document, whether my case falls within those or not.
All right. Mr. Chakravarti, learned advocate, appears for the petitioner through virtual mode. None appears for the bank. To stop, list this matter in the next week under the same heading. Next. Call the next matter.
56.
As I appear for the petitioner matters, I am being led by Mr. Abratosh Majumdar, who is appearing virtually.
Who is opposing you?
My lords, I am being led by my senior, Mr. Kosik De.
Yes.
So, due to some personal difficulties, he cannot appear today. My lord.
He has not come.
He has not come to court. My lords, there's some urgency in the matter, my lords, because I've already furnished a bank guarantee, my lords, and that is a fund-based guarantee, my lords. I'm incurring cost on this on a daily basis, my lords. So therefore, my lords, I understand will not do this matter without my lords can kindly fixes it, my lords.
Monday?
Monday.
Not today, next.
Much.
'85.
85, I again beg to appear on behalf of the petitioner. I'm again sorry, my lord, I had to appear virtually. My lord, here, my lord may remember this matter. It was taken up a number of times. Here, I have challenged the order of the internal complaint committee, which after holding me that I am not guilty of the charges against me has not been proved.
In spite of that, a recommendation has been made.
Yes, correct, my lord. That is the point, my lord. My lord, the urgency being in item number 88.
But nobody is opposing, is there to oppose your.
My lord, every time, only once they appeared, my lord, time and again directed us to serve a notice. We have served notice, again came back. My lord, the urgency, why today I will be pressing for the urgency, let it be on Monday. I will try to again inform them. But my lord,
I'm making it not today.
My lord, the urgency is that the petitioner number in item number 88, the petitioner is going to retire next week. My lord, next week, 31st. Next week. So, my lord, if my lord, on Monday, if it can be taken up, because this is my only urgency, one matter will dispose of practically the other matters. Because, my lord,
Monday, Ashun. Mr. Chakravarti, learned advocate, appears for the petitioner. This is in item number 85.
85 to 88.
No, but I think there is some.
Yes, my lord. What is that? 85 and 86? Not guilty?
In which item the petitioner is going to retire next month?
88. 88.
তাহলে 88 টাতে রেকর্ড করুন একখানা অর্ডার. Mr. Chakravarti, learned advocate, appearing for the petitioner, submits that the petitioner in WPA 10687 of 2021 is going to retire in the next week. As such, he prays that this matter be taken up on an urgent basis. First up, list this matter. List these matters, 85 থেকে 88, under the heading fixed matters on Monday করে দিন.
Grateful, my lord. I am extremely grateful, my lord.
Call the next matter.
'89. 89, I'm for the petitioner, my lord. Mr. Parthasarathi Devbarman is appearing in this matter. He is engaged in another court. So, my lord, I'm praying for short passover. My lord.
Passover next.
91.
91 দেখি।
91, my lord, I am for the respondent.
KMDA. Who is for the petitioner?
Got the brief also. 91 will be called.
Yes. What is your submission? He says the proceedings lapsed, Act 2. That is their prayer.
Brought the brief today. Make it not today.
You have not got the brief.
No, I have not brought the brief today.
Not today. Next.
'92.
My lord, 92, my lord. Mr. Devnath Ganguly is appearing on behalf of the petitioner, my lord. My lord, due to illness, he has not come today. Only I'm praying for not today, my lord.
Not today. Next.
Deeply obliged.
93.
93, 94, I placed for not today, my lord.
Why?
Mr. HON'BLE left the court for his medical checkup, doctor's appointment, my lord.
Not today. 93, 94, not today. Next.
95.
Your Lordship, I am appearing for the petitioner being laid by Advocate Somu Mojumdar. I am praying for not today, Your Lordship.
Basu is appearing on behalf of the rest.
Not today. Next.
Grateful.
96.
Lord, 96, I am appearing before the petitioner, my lord. There was a direction to file affidavit in reply. Lord, it is ready, but the person who is authorized to sign the same could not come. I am praying for not this week, my lord.
I am appearing on behalf of the market committee.
Not this week. Not today will not.
My lord, kindly. Not
Not
this.
today or not this week.
My lord, the next week as well, my lord.
Not today. করে দিন।
My lord, item number 120 and 120 are similar matters, my lord.
Wait. Yes. Next.
Lord, this
Good.
time may be extended by your lord.
Call the next matter.
7.
Lordship, 97 to 112, Shayok Ranjan Manage is appearing in this matter. I'm praying for a short passover.
Passover next.
98.
97 to 112, all analogs.
Yes. 97 to 112. Yes.
113.
দেখি। ফাইলটা কোথায়? শুধু তো অর্ডার শিট। ফাইলটা আছে? Not today. Next.
114.
Lordship, in item number 114, I'm being led by Senior Advocate Mr. Jayanto Mitra. Lordship, I'm praying for a short passover.
For the petitioner.
Yes, Lordship. Thanks.
Lordship, I'm appearing for IIM. I'm led by Mr. D.N. Ray in this matter. Due to some personal difficulty, he's not present today. I'm praying
You are
for
here. You are here.
Your Lordship, I'm led by him.
You are the advocate on record.
No, Your Lordship. No, Your
You
Lordship.
said you are led by him and you are not the advocate on record.
My senior Bhaskar Mukherjee is there.
Affidavits are complete.
Yes, yes, Lordship. Affidavits are.
Are you challenging any decision of the authority?
Lordship, initially the petitioner was appointed as a assistant professor. So then a scheme was there under which he was appointed. Subsequently, he was made permanent. Then the scheme changed. The authorities accepted, but after retirement, the benefits which he is supposed to receive from that scheme, they're not disbursing that.
So that is in terms of the minutes of the 85th meeting.
Yes.
You want implementation of that?
Yes.
Yes, when Mr. Rai will be available?
Lordship, Monday.
All right, not today. Next.
Grateful, Lord.
Grateful, Lordship. Monday, Lordship, it will retain the position, Lordship, because.
Retain its position. Yes, next.
Grateful.
My lord, passover matter item number 89.
115, yes. Not today. Next.
But I appear for the respondent corporation.
Respondent.
Lordship, led by Mr. Raghunath Chaupati. Kindly give short passover, Lordship.
Paper book has been filed.
It is in paper book form. All the papers from the opposition reply, and then it is a direction by the court, my lord.
What is this matter, Mr. Ghosh?
But regarding the cancellation of a sanctioned building plan.
Cancellation of a sanctioned building
sanctioned
plan.
building plan. However, there are certain orders of the division in the earlier round of litigation, and in fact, on the basis of that sanctioned building plan, the court directed.
That order is being challenged by the petitioner.
No, court matter initially at a order was passed, you will also see that earlier round of litigation, the
Yes.
division bench passed an order. That is that page just I'm pointing out. Page, my lord. One two nine. Also, can you see the order?
129.
Yes, my lord.
There is no page 129. Is it two volume?
No, no, one volume.
এই পেপার বুক আছে? Yes.
This is an earlier round of litigation regarding that particular issue. And then you will see, my lord, page 51, the judgment of the earlier round of this is where in connection with this, what my lord is looking at. This is connection with this case, but earlier round of litigation, the order of the division which is at page 51. You can see.
51.
51.
No, petitioner is the complainant or he is the
Complaint.
He is the complainant. Now, his complaint was that in the garb of repairing, a new construction was being made.
No, in the garb of repairing, that is a separate issue for which, my lord, after obtaining a sanction plan, whatever the violation is there, for that reason the proceeding had been initiated. But he is questioning that the plan which has been sanctioned under a particular provisions of law, that could not have been granted by the Kolkata Municipal Corporation.
397.
It is not really 397 because the court granted him 397, but it is not really 397 because he did not. It is not a case of the suppression of any fact before us. Whatever
But
is there.
The question of cancellation of the plan arises only under section
Only under section 397. And he says, my lord, this plan ought not to have been sanctioned under these and provision. Because it is a sanction ought to have been given under a particular section. This is his case. The private person is also there in this particular matter, my lord.
And a similar situation are also covered by a division bench judgment. The plan, there is a provision, certain things are to be done by way of sanction building plan, not by way of repairing. Here under Rule 32E.
According to you, it does not fall within section.
Yes, my lord.
Rule 32 of
Yes,
the building rules.
It is a complete plan is required to be taken in terms of the Rule 4 of the
What
building
is the
rules.
nature of the work which is
Massive construction. I will show, my lord. Roof, my lord, the staircase, water reservoir, what not. In the civil code, they themselves declared. I'm just showing, reading, my lord. What
you want revocation of the
But
sanction?
yes, one thing you also see, my lord, the order at page 51. That is I am pointing out.
51.
Because, my lord, the court, the earlier round of litigation on the industry, the same issue regarding that plan, the court directed regarding the construction to complete in accordance with that sanction plan.
No, my lord, what happened? My lord, initially we are of the, my lord,
Page 51,
Page 51.
Mr. Chakraborty's
Lordship.
client is the petitioner or the private respondent?
No, petitioner is a Gautam Rai. He is of the petitioner
Oh, he's the
Gautam Rai.
petitioner. Gautam Rai, yes. So he was the petitioner. He was the petitioner in that matter.
Yes, my lord. Because
Lordship.
in the earlier round of petition, whatever the order was passed by a single judge, he came before this court, my lord, with this application, the appeal. Then the court passed an order because it is, my lord, arising out of that order, the subsequent, my lord, proceeding.
At that point
But
of
it
time,
needs to be, my lord, looked into what the order is.
Let me go through this order.
my lord, kindly see page 66 also.
Give me a minute. So there was liberty was given to you
Yes.
to apply for cancellation.
Yes, my lord.
You have done that.
Yes, my lord. Then, my lord, kindly see page 66 for a while.
Cancellation, you can see, my lord, the one thing, the
Page
cancellation.
66, what are the construction to be done by them by way of a,
No, after that you have applied for cancellation. Where is that
yes, my
representation?
lord. Page 66, lordship will find what kind of construction they are doing, taking plan under rule 3.2. Is it permissible, my lord? We put this question to ourselves.
In
Page
this civil
66,
suit, the municipality is corporation is the party.
in civil suit, my lord. I am to inquire.
This is a civil suit.
Possibly,
Page
my lord,
66 is an application under Order 39, Rule 1 and 2.
Yes, my lord.
Title
Yes.
suit number 1625 of 2000.
Prior to an institution of, my lord, the writ application, this civil suit they have moved, and application under Order 39, Rule 1 and 2 they have obtained. Here, my lord, kindly see paragraph 5, reconstruction of stair by demolishing the existing one entirely and introducing new 4-column RCC landing way slab and surrounding brick walls. Reconstruction of first floor roof. Reconstruction of balcony, construction of parapet wall, construction of.
I will come to that, Mr. Chakraborty. Pursuant to this leave granted by the Honorable Division Bench,
Lordship.
did you apply for cancellation?
Yes, yes, yes.
Where
my
is
lord.
that represented?
I'm
one
trying
thing,
to
my
find.
lord, kindly
I'm
see
trying to
one
find
thing.
it out.
In the order of the division bench, he could not satisfy the court because the court, my lord, in one way, although, my lord, granted him liberty, my lord, to if the law permits so, but the court also direct the party, the person concerned to whom the sanction was granted, to entitled to carry out the construction work, repair work as sanctioned by the corporation, though it has been submitted by the
As
appellant.
sanctioned by the corporation.
But that is, my lord, in terms of that order, he could not satisfy to stop the construction or, my lord, in any way. But although at the end the court said as he prayed for, but the court at the same time, my lord, directed division bench to complete the work, my lord, in terms of that sanction building plan.
To that there is no dispute, but Mr. I think Mr. Chakraborty's submission would be that the plan
Lordship will find
Yes.
page.
did not have been granted.
So
Yes,
that's why
yes,
two things
yes.
are there.
Yes.
Two things are there, my lord. If the construction is completed or done by virtue of a sanctioned plan, which, my lord, stands, my lord, the automatically has already been completed, my lord, sanction has been effected already, then it could be hard, my lord, whether in, my lord, it will be an economic one to consider that whether the in terms of that, my lord, the provision of the law, the sanction could be granted or not. But
So is it the, Mr. Ghosh, is it the law? If let us suppose a plan has been obtained. Let us take a hypothetical case,
My
not
lord.
this case.
The
A
feeling of
plan
the
has
court,
been obtained by way of suppression or material
yes, that is the
misrepresentation.
suppression
So
is a different
even,
thing.
so even,
I'm
no,
not
no, no.
finding an issue with that.
So even if construction has been completed in accordance with that plan,
But a
is the
suppression,
corporation stopped from
no,
revoking that plan?
suppression of fraudulent misrepresentation, that's a
So-
completely different thing.
Yes, yes.
Because sanction would not have been granted. But the question is, my lord, if the persons, my lord, come with the open, my lord, case that he is submitting all papers to us, my lord, that is not a suppression. He says, law says that senior.
So according to you, this could be if only
Is a
It
material
falls within
misrepresentation.
397.
There is a material misrepresentation and fraudulent statement.
So
on
if
which
it
the
falls
plan-
within 397,
Yes,
if it
that-
falls within 397,
Otherwise, plan could not have been sanctioned.
all right.
But here, that is not the case. Therefore, I am.
Yes, yes, Mr.
Page
Chakraborty.
80, my lord, my representation before the Kolkata Municipal Corporation, demand for justice, calling for cancellation, rescinding the above mentioned sanction plan, granted under Rule 32E, violation of the provision of the KMC Act 1980 and the rules framed thereunder.
32
E.
are these.
T2,
Kolkata
my
Corporation
lord,
Act.
here we have quoted, my lord. Page 83, lordship will find. Page 83, lordship will find paragraph 16. It is provided under Rule 32E, minor repair. Rules with me, my lord.
Not a West Bengal, na, Kolkata Corporation rules. নেই আমাদের কলকাতা কর্পোরেশনের বিল্ডিং রুলসটা দেখুন তো।
অমৃতা সিনহা করে একই মামলা করলেন, কি হলো সেটা?
Yes, Rule 32. It is where permit is
Minor
not required.
Yes.
This
not-
falls under Rule 32.
Yes, only required in a case.
Not required.
Only, my lord.
Notwithstanding, no building permit shall be
Yes.
required for this.
Kindly Rule
So
32E.
that is what I was saying. Rule 32 does not
32
speak of sanction.
32E may kindly be looked into.
Yes.
Minor repairs, reflooring of an existing damaged roof without changing the character and dimension of such roof. The proviso under this sub-rule state as follows: provided the character of the damaged roof may be allowed to be changed and its reconstruction permitted by permission in writing. They are taking this plea, they have taken this permission in writing, which they are treating or, my lord, showing as their
So
plan.
according to you, their work falls within clause E.
Only, my lord, the damaged roof, my lord, by way of taking permission, they can do, but they cannot do. Lordship, kindly see what kind of work they are doing. Page 82. Page 82, my lord, reconstruction of stair by demolishing the existing one entirely and introducing new 4-column RCC landing, waste slab and surrounding brick wall. Reconstruction of the first floor roof. At best, my lord, this can come within this Rule 32E, the plan which they have obtained. Reconstruction of balcony, construction of parapet wall, construction of SUGR. My lord, this is
Roof can be reconstructed without changing the
nature and character
and the dimension.
Yes, my lord.
That can
Our-
be done.
Our humble submission, my lord, here, by way of taking plan under Rule 32E, they are doing, my lord, the massive construction. Lordship will find, my lord, the photograph. Lord, kindly come to my lord.
So what happened to this representation?
My lord, nothing done. Then, my lord, this writ application, exchange of affidavit, and it was before Honorable Justice Abhijit Gangabadhyay, as his lordship then was, my lord, directed us to file, my lord, paper book, and directed Kolkata Municipal Corporation to file their affidavit. Page 76 may kindly be looked into.
Where
Lordship
is
will
your
find.
prayer in the writ petition?
I'm coming, my lord.
Page 25.
25, my lord. Rescind the impugned sanction plan. Declaration declaring sanction for repairing cannot be utilized as a sanction for reconstruction of building or reconstruction. So, my lord, division bench is very specific in this regard.
No, this plan was repairing plan.
Yes, they are taking this plea and, my lord, doing this type of construction. Lordship will find from page.
Where is that? Do you have a copy of that plan?
No, my lord, they never supplied us. Even, my lord, they have, my lord, the referred in their civil suit. We requested them to supply all the papers. This is yet to be honored. Till today.
Mr. Ghosh, is the plan which he has challenged styled as repairing plan?
They are trying to say.
Because, my lord, what is the stamp? that
Because
is
I
giving?
find from the paragraph,
My lord.
from the prayer, they have termed it as repairing plan. Is there anything
Well,
called as repairing plan?
repairing certain reconstruction works. Not only the repairing certain reconstruction is also allowed in a my lord, the small premises, the surrounded by my lord, the old premises.
It is styled as addition alteration.
Addition alteration, my lord, it has not been styled as, but the certain provisions are there for which my lord,
Repairing plan is permissible.
certain my lord, provisions they have applied. You may look into that. The plan, my lord, which is there, the private person is also here. They may have their own, my lord, they could be served, my lord, the notice, my lord, to be ought to have.
Only
be
one
present.
thing, Mr. Ghosh,
My lord.
if they have made this representation as page 80, why it is kept pending? You could
My
take
lord,
a decision on this.
immediately thereafter, he came to this court.
So you have to take a decision on
I
this.
may take a decision, my lord. It may also be a futile exercise in the sense because the plan had already been sanctioned by us.
You may say so.
My lord.
Your,
That
yes, Mr. Chakraborty, I am
of course,
directing
my
you
lord.
to take a decision on this
My lord,
after hearing you as well as the
Private party.
private parties.
my lord, within a very short span, my lord, the person is, my lord, senior citizen, hovering in between life and death. He wants to, only one photograph may kindly be looked into, my lord, because for my
Produce that before the corporation.
for my satisfaction.
Produce that before the corporation.
I know,
We're
my
not
lord.
going to examine that.
No, my lord, for my satisfaction, my lord.
Mr.
Just simply, my lord.
Chakraborty, now the corporation is very busy now.
Yes, my lord. Tilting building, my lord. And my lord's plan is sanctioned.
One of his cases, tilted building, my lord.
So IIT, my lord, IIT entrusted.
Tilted building.
IIT entrusted.
The petitioner in which
Petitioner in that
IIT entrusted IIC, my lord,
IIT
prescribed.
also the reporting
longer period in this, Mr.
Yes, my lord.
Chakraborty.
IIT entrusted.
Then a longer period in
Here,
this.
my lord, 2-storied building sanction, 6-storied, my lord, before the nose of Calcutta Municipal Corporation, which has been tilted. So for my premises is concerned, IIT entrusted, IIT, my lord, filed the report. But my lord, one request, my lord, indulgence. Page 75. For a while, my lord. I know, my lord, this is nothing. Page 75. Kindly see, my lord, the repairing, nature of repairing. Page 75, 76, 77, 78.
But there is also allegations against him also.
No, he is the owner of an adjacent premises.
I mean, in a ground floor and first floor. This is the position. In the same premises.
So, my lord, then, my lord, Bashana
Same
Datto.
premises, two owners.
Flat
So, my
owner
lord,
of the same
Yes,
we are-
same
then, my lord,
building,
we
in
are
the same
co-sharer.
whole premises. In one part he, another part.
My lord, then we are co-sharer.
That is the
The
difficulty.
consent of co-sharer is mandatory. My lord, kindly recall the Bashana Datto judgment.
All right, Ashun. The
My lord, with certain observation, my lord. Otherwise, my lord,
what observation?
KMC, my lord, Lordship knows, my lord, in review.
Chakraborty, if I have to make some observations, then the other side has to be hard. I'm keeping it open. Raise all points before the authority. The grievance of the petitioner is that the representation submitted by the petitioner praying for cancellation of the sanction plan dated
Madam, this is, my lord, 3rd December, page 82, my lord.
dated 3rd of December 2021, issued in favor of the private respondent.
Yes, my lord,
Issued in favor of the private respondent.
Memo number may kindly be indicated because under Rule 3.2, this was.
কি বললাম? The petitioner has prayed for bearing serial number না page 25 এ paragraph এতে করা আছে serial number such and such dated এত issued in favor of the private respondent hearing has not yet been acted upon by the Kolkata Municipal Corporation. First up, Mr. Ghosh, learned advocate, appearing for the Kolkata Municipal Corporation, submits that immediately after submitting the representation dated 4th of May 2022, the petitioner has approached this court, and for such reason, the corporation authorities could not take any decision as the matter is sub judice before this court. First up, after hearing the learned advocate for the petitioner and after hearing Mr. Chakraborty, the learned advocate for the petitioner, and Mr. Ghosh, the learned advocate for the Kolkata Municipal Corporation, this court is of the considered view that the appropriate authority of the corporation should be directed to consider the representation dated 4th of May 2022 and to dispose of the same after giving an opportunity of hearing to the respective parties. In view thereof, the writ petition being number such and such is disposed of by directing the
Boro hota 11 boda. 11. My lord, Boro 11.
Exhibition of the consent Boro.
By directing the which respondent?
Exhibition, let me know.
By directing the
my lord,
executive engineer, building Boro 11, being the 8th respondent.
Yes.
This is also in Bagajotin, Mr.
Yes, my lord.
Bagajotin. Being the 8th respondent to consider the representation of the petitioner dated 4th of May 2022, and after giving an opportunity of hearing to the petitioner, the private respondent, and any other parties who may be affected by the decision of the Kolkata Municipal Corporation or their authorized representatives, and to dispose of the same by passing a reasoned order as expeditiously as possible, but positively within a period of 4 weeks.
2 months, Your Lordship.
No, my lord.
2 months.
No, my lord.
6 weeks from the date of
Death certificate to be
receipt
registered
of
in that case,
a
petitioner.
server copy of this order along with a copy of the representation dated 4th of May 2022. It is, however, made clear that this court has not gone into the merits of the claim made by the petitioner in the said representation. First of the parties will be at liberty to raise all points before the 8th respondent at the time of
But
hearing
only one indulgence,
eighth
my lord.
representation.
The executive engineer or Bureau 11,
ওইখানে বলে দেবেন, needless to mention that the reasoned order shall be communicated to the parties immediately thereafter.
but the executive engineer of Bureau 11 is my client as far as one service matter is concerned. In that case, my lord, deputy chief engineer, no, my lord, no, my lord, no, my lord, deputy chief engineer, my lord, of Calcutta Municipal.
Authorized or the Director General, Mr.
Deputy Director General, my lord,
Authorized the Director General, my lord.
তাহলে করে দিন, the Director General building দেখে নেবেন কত রেসপন্ডেন্ট, 3rd না 4th আছে, or any of his delegates.
Lords.
Lordship will be sitting second of.
My lord, I have mentioned the matter in the morning, which was allowed. My lord, however, my lord, I have been told, my lord, there is no list of original site, my lord. The matter was of original site writ
No, no,
petition,
no.
my lord.
Appellate side.
Lord, my lord, be kindly accommodate us for a hearing, my lord. The matter is
Then I will have to, because the officers are also not here.
And one appellate side mentioning in the morning, I am on the impression, my lord, lordship will sit in.
Mention on Monday. Yes. Call the 2 p.m. fixed matter.
I will again mention out of Monday, my lord.
Item number 15 fixed at 2 p.m.
Well, I am appearing on behalf of the petitioner, my lord. This is a.
Yes, my lord, both we are true, because we prepared an appeal and in the meantime, regime order had already been passed. Therefore, contempt application to be dropped.
Yes.
Why contempt order to be dropped?
What was the direction?
To demolish the illegal construction, my lord.
There is some delay, Lordship. What was the order?
My lord, kindly come to 22nd September 2023. The petitioner prayed for a direction upon the municipal authority to demolish the alleged illegal construction raised by the private respondent number 4. The petitioner has alleged that the private respondent has made an illegal construction by encroaching upon the common passage. Pursuant to an order dated January 16, 2023, an inspection was carried out by the assistant engineer of Rajput Municipality. An inspection report has been filed. After going through the inspection report, this court finds that the assistant engineer has opined that the construction made is illegal as there is no sanction plan. In view of the aforesaid report, this court directs the Board of Councillor of Rajput Municipality to initiate appropriate proceedings in accordance with law, taking note.
Yes, demolition. So order has been passed. You have to challenge this. Have you served a copy of the reasoned order?
Sir.
Give them a copy. Ashun. The learned advocate appearing for the petitioner submits that the order passed on 22nd of September 2023 in WPA 2571 of 2018 has not yet been complied with. The learned advocate appearing for the alleged contemner submits that a reasoned order has been passed pursuant to the direction contained in the order dated 22nd of September 2023, passed in the aforesaid writ petition. Since after going through the reasoned order has been passed on reasoned order has been passed on 13th of October 2023. The reasoned order is on 13th of October.
22nd September.
No. The reasoned order.
Lordship.
So 22nd of September.
September 2020.
Within how much time it was directed to be?
Positively within a period of 6 weeks.
6 weeks. So it has been done 22nd of September, 13th of October. Since the reasoned order has already been passed, this court is of the view that the order and directions contained in the order dated 22nd of September 2023, passed in the writ petition, has already been complied with. Let a copy of the reasoned order be supplied to Mr. Bhattacharjee, learned advocate for the petitioner. First up, it will be open to the petition. It will be open to the respective parties to take appropriate steps if they are aggrieved by the said reasoned order. With the aforesaid observation.
It was hard. An exception to the report I have
already. This reasoned order you have not challenged. Reasoned order they have passed. Kindly go to.
Kindly see, my lord. What
demolition order was passed.
What order was passed?
We challenge this rescind order by filing one writ petition.
This rescind order is under challenge.
Rescind order was passed, but kindly see the order. Kindly see, my lord.
Yes.
But they have already filed rescind order. Exception to the kindly see, my lord. Supplementary evidence.
No, rescind order you are challenging by way of a supplementary affidavit in the contempt.
Yes.
That cannot be done. You have to challenge.
Order was passed during pendency of the contempt application.
That may be.
But they have not complied, my lord.
During
See the
during the pendency of the contempt application.
Yes.
When you have filed the contempt application. When you have filed the contempt application. Contempt application, Mr. Bhattacharya was on 2024 and this rescind order has been passed in 2023. How are you saying it was passed during the pendency of the contempt application?
Well, kindly see, my lord.
Mr. Bhattacharya, the rescind order was dated 13th of October 2023. You have filed the contempt application in 2024 subsequently.
Contempt application was pending during pendency of the contempt application.
What is the date of the rescind order? And when have you filed the contempt application? The contempt application is of the year 2024. How can it be during the pendency of the
rescind order was inspection was as per direction of the my lords. Inspection was held on 24th January 2023.
The rescind order, kindly go to the rescind order. What is the date of the rescind order? Kindly come to a supplementary affidavit.
This order was passed 13th October 2023.
And it was served on 30th of December 2023.
But thereafter, my lord.
When have you filed the contempt application? It is in 2024, Mr. Bhattacharya. Your contempt application is of 2024. How can you say it's during the pendency of the contempt application?
Yes, my lord. So, my lord.
Mr. Bhattacharya, if you are agreed, we have to challenge by filing a writ petition. In the contempt, it cannot be. The Ashun. Dated, said rescind order dated 30th of October 2023. With the above observations, the contempt application stands disposed of. Yes, next.
24, my lord.
Yes, so contempt is subsequent. Rescind order is previous. So, Mr. Bhattacharya, in a contempt application, it cannot be the propriety of the order cannot be decided. You have to challenge afresh. Yes, next.
Grateful.
Line at Kodadin. It is well settled that the propriety of an order cannot be challenged in a contempt application. In view thereof this court.
Leave may be granted to file a fresh.
I've given leave. Parties will be at liberty to take appropriate steps if they are aggrieved. Yes, next.
117.
Mr. Mohan Kumar Putapinda is appearing for the petitioner. Not
today, next.
118. 118.
Lord, short point is involved in this case. Lord, short point is when a property is acquired under the National Highway Act, whether Land Acquisition Act 2013 applies. Because
I think that act has been incorporated in the schedule of the 2013 Act.
100 section 105.
Yes,
And Supreme Court judgment is also there.
yes.
Now they acquired the land. We challenge the acquirement of the land on the ground that objection was given because this is a factory. Now 100
Award
employees,
has been declared.
Lord, according to them, award has been declared, but I was not given any notice to that.
Mr. Banerjee, this is an
Even if
arbitration
award
award.
is
You have to challenge
Lord,
in the manner known to
one
law.
minute, not 1 minute. I know that, my Lord. But even if award is
Recently, Mr. Banerjee, on
yes,
this.
yes. I'm saying that, my Lord. Even if award is declared, they may be directed to supply the copy of the award so that I can make a reference to that. Only to that extent I make a prayer. Second was that under section 5A of
Mr.
the
Banerjee, until and unless, because the limitation starts from the date of service of the award.
that
So if
is
they
the
have
reason.
not served the award,
Lord, that is the reason. That is the reason I say that because I cannot
you have not
be
served
able
the
to
award.
withdraw.
My lord, I am appealing on behalf of the National Highways Authority, my lord.
Well, let
regarding
me-
the-
Competent authority is your authority.
Yes, my lord, but they are the
To serve the
custodian, my
award.
lord. They are the custodian of the award, my lord. They are the
Who are
state,
the
my lord.
custodian of the
My
award?
lord, the competent authority under land acquisition, my lord. But
Who is representing the competent authority?
Because my limitation will not commence unless it is
Yes.
served.
Your
And second
limitation
point,
will not start to run.
Lord,
Mr. Chondicharan,
Lord, second point, only second and third. Lord, second point, I am telling your Lordship. That part, Lord,
That's all your
will be
points
ordered. Yes.
in section
So far, that
34.
part is concerned. Now, second point is concerned. I am telling your Lordship. What law is, my Lord, subject to my Lord's acceptance, that we filed objection against the declaration, that is under section 3.
Against
Against the notification seeking objection under section 3 of the National Highway Act. Like section 5A, we raised objection saying alternative accommodation be given apart from compensation in terms of 2013 Act. The Supreme Court judgment is at least one reasonings, brief reasonings must be given. Otherwise, entire scenario will go. That is the judgment of the Supreme Court. Now that argument possibly I cannot argue at this stage.
the award has been passed.
Lord, that argument I cannot possibly at this stage. Supposing, Lord, your Lordship accept my argument, then they will comply with that thereafter. But they have already taken possession.
Award has been
Therefore,
declared.
second point goes. Therefore, I will not argue on that point. Number third, alternative. They did not. That is the argument whether that is they are liable to give or not. That argument I will advance before your Lordship. First, my Lord, with regard to the award given, it was not known to me, for which I could not be able to withdraw it. Therefore, let them serve the copy of the award so that after the perusal thereof, I will see that
You may
according
even
to.
accept that.
Yes, I will accept.
You may even accept the award.
With objection, I will award. Therefore, reference is to be given, and then it will be heard by the reference court. So far that part is concerned, only that limited relief I want. Lord, so far the third relief is concerned. Second relief I need not argue because in view of the possession is
Against
taken.
the competent authorities award a reference to an arbitrator.
Yes, reference to an arbitrator. Previously, my Lord, under 3.8, reference to arbitrator.
my lord, one document, my lord, if your lordship kindly allow me to place, because lordship, it's a very illegible copy, lordship. Just now, lordship, I have received.
What is that document?
My lord, the document is, my lord, the petitioner, my lord, wrote a letter to the special land acquisition officer, my lord. My lord, I just read, my lord, with reference to the above Gazette of Calcutta dated 10th January 2022 for acquisition of above mentioned RS dark number such and such under National Highways Act, we had submitted our requisite documents with letter dated 4th October 2024 received by your department on 4th October 2024 to claim compensation and solicium as per determination in your record under section 3G of National Highways Act 1956 related to the mentioned RS dark number except RS dark number 382 against LR Dag number 644, my lord, except, my lord, because they mentioned name change in ownership is pending with BLRO, case number such and such, because they admitted, lordship, that the case is pending. We hereby request you to acknowledge receipt of requisite documents to process our claim for compensation and solicium as determined under section 3G for acquisition of respective plots number such and such under National Highways Act to respective land owners bank account except for RS Dag number such and such. As title suit matter, name change in ownership for the said plot is pending for mutation with BLRO case number such and such. We shall intimate you later to claim compensation and solicium for the said plot after name change in ownership is completed, my lord. This letter is lodged 15 January 2025.
Right, because it is in view of the fact that in the record of right, the name of the tenant, that is, that name of my tenant, my premises tenant, he claimed to be the Thika tenant in respect of the property. But accordingly, his interest is vested. His name, he wrote no, I'm telling your lordship. Lord, he wrote a letter, he gave notice to them, not to me. Then, my lord, I filed a suit for eviction on the ground that he is a premises tenant governed under the Premises Tenancy Act.
Not a Bharatia under the Thika Tenancy Act.
Not a Bharatia under the Thika Tenancy Act. We got a decree. Appeal, we got the appeal being dismissed. Second appeal being dismissed. There the argument was that
You have got the decree executed.
I got the decree executed and
got possession.
got possession.
You have got possession.
Got possession.
You are in possession.
I am in possession.
But
And
you have
he took delivery of possession from me.
Their last line mentioned, we shall intimate you later to claim compensation solicium for the said plot.
Oh, that is not the objection, madam, kindly. That is not the objection against that.
All right,
Objection is alternative be given. And now I cannot praise my objection in view of taking possession. Therefore, why you are arguing this? Immaterial.
In this matter, my lord, I may
You
be
could not
permitted
follow
to
my
file the
argument.
objection, my lord. In this matter,
What objection?
my lord, regarding some
You
documents.
are granted liberty to file a report. You have not done so.
Yes, he has done.
My lord, give me another.
19th of July 2024.
Affidavits are complete. They
My lord, give me
affirm that
another chance, my lord, within a
It
week.
is complete.
Yes.
So what report?
Affidavits are complete.
All right.
Only whether alternative accommodation you are liable to give or not.
Then, my lord, I-
Mr.
I
Banerjee
filed
Lanet,
the case, my lord.
what is that?
This is the report, my lord, as per the.
No, this is the
Copy in.
affidavit in opposition.
Yes, my lord. My lord, so as per the direction, lord, copy the sir, apnake.
As per
No,
the
that needs
direction.
to.
When direction was passed to file affidavit in opposition? Because direction was passed to file a report in the form of an affidavit. Where is the order direct giving liberty to file an affidavit in opposition?
My lord, maybe in the month of July, my lord,
July of?
2024.
No, not an affidavit in opposition. On January 9, 2024, a copy of the report was made over to the line, and on the prayer of the petitioner, was granted opportunity to file a report in the form of an affidavit, not opposition.
Then my lord can give me the liberty, lordship, to I file the lordship, the report, lordship, because some documents are required to be produced before your lordship, my lord.
Need not.
We
My lord,
file a
entire-
report, not this
My
opposition.
lord, I will.
Better near in.
I
The learned advocate appearing for the So you have filed that report in March 28, 2024.
Yes, that has been filed. Report has been filed, my lord. That report I have annexed in my
Yes.
supplementary
And he has
affidavit.
filed, he was given liberty to file an exception.
Yes.
ঠিক আছে, লিখুন।
Then
Mr.
nothing
Banerjee,
remains. My
learned
lord, let me
advocate,
conclude my
appears for
argument.
the petitioner. Ms. Chaudhary, learned advocate, appears for the National Highway Authority.
My lord, Monica Roy, my lord, Miss Roy.
Monica
Roy, my lord.
Roy. Ms. Monica Roy, learned advocate, appears for the National Highway Authority. Full stop. None appears for the state. List this matter in the next week under the same heading. Petitioner is directed to.
My lord, as a continuing matter, my lord, otherwise, my lord, this is a short point. Lord, I will not much argue. I told you, lordship.
I have not heard, Mr. Banerjee.
No, that
The
is right.
opening point.
Lord, otherwise, when it
Continuing
will,
matters, Mr. Banerjee, I am
then
placing
it may be
those which are substantially hard. Otherwise,
then
all
my lord,
matters are to be
right, my lord.
placed.
Then it may be, my
So
lord,
let it
especially-
appear.
It
Mr.
may be especially fixed on that day, according to them.
Let
I am
it
ready.
appear. Let me see how far I can proceed.
Lord, I am
Discuss
ready.
matter in the next week. Take your chance in the next week. Yes, next. The learned advocate for the state about the next date of hearing. Yes.
Lord, I will give notice to them so that, my lord, they may appear.
Yes. Only the next
119.
date of hearing, nothing more. Notice regarding the next date of hearing.
Next date of hearing, my lord, that
next week.
Yes.
Or I will place it.
Kindly fix it at 2 p.m., my lord. Any day, fix
2
it at
p.m.
2 p.m.
2 p.m. is the difficult.
2 p.m.
2 p.m. Let it appear in this way.
Or the day, my lord, at least a day may be mentioned so that I can give notice. Very short point, lordship.
I've given
And
you next.
before your lordship, my lord, at once court hold the point.
No. Next week it will appear. Yes, next.
119. Then, my lord, I shall give notice in the next week. It will appear. Lordship.
My lord, I am for the private respondent, my lord. On last week, my lord directed to give notice to the advocate for the petition. I have served notice, my lord.
They are not appearing.
Not appearing. My personally, I talked to him. His client is not no more interested to proceed.
All right.
If you lord kindly see, my lord, page my lord 29, the order of the board, my lord.
But the respondent files a letter addressed to the learned advocate for the petitioner dated 19th of November 2024. On 19th of November 2024, the petitioner was not represented and the hearing of the writ petition stood adjourned. In spite of notice, none appears for the petitioner even today. First up, the learned advocate appearing for the private respondent prays for dismissal of the writ petition. First up, state is represented by its learned advocate. Since the petitioner is not represented, the writ petition stands dismissed for the court. Interim order, if there is any interim order.
Yes, my lord.
Interim order, comma, if any, comma, stands vacated. Next.
Get put in.
Under 20 and 21.
Upon instruction, I am appearing on behalf of the petitioner, my lord. I am praying for not today. My lord, item number 96 is a similar matter, my lord.
You are praying for not today?
Yes, my lord.
Not today, next.
My lord, let the three matters be taken up together. my lord.
Matters, my lord, earlier it was listed before your lordship. Then, my lord, they didn't take any step. It was gone, go out of list.
What is the other matter? 96.
My lord, 96, my lord.
Let that be taken up there. Then at the time of hearing, you mention this.
Great.
If all of you are ready, then I will take it up.
Okay.
Yes, next.
Under 22.
My lord, I'm praying for not today, my lord.
Not today, next.
Under 23.
I'm praying not today. I'm praying not today.
Not today. Why? Who is appearing? Not today, next.
Under 24.
Under 24 on behalf of Mr. Mukherjee, Tanmay Mukherjee.
Why?
A monthly list, my lord. He's engaged in 2 p.m. matter and coming week he will not be available.
Busy lawyers will remain engaged.
not that. Next week he will
No,
not.
I'm appearing for a number, Union of India, my lord, here.
Busy lawyers will remain engaged.
No.
I'm for Union of India, Referendum 1 to 3, my lord.
Yes, what is this matter?
I'm not reading blood.
क्या नाम था, क्या एरिया का नाम था? What is called? एरिया को क्या बोलते हैं? No, there was a restricted area in district Hooghly, and the state of West Bengal were constructed the building within 100 meters. So stay was granted earlier.
Yes.
A protected area was there. So A temple is there nearby. They have filed this thing. This Ravayat and all this. महानद महानद तो है महानद ही एरिया इज महानद
Jateshwarnath Shiv
What is applications? What is this application about? Can 3 of 2019?
190p. Yeah.
Appropriate order, not.
What is the appropriate order you are praying for?
Well,
What according to you is the appropriate order,
my
which the court should pass?
Well, the building has to be done.
Straight for blood. So that the matter can be hard out, but there is.
That is
What
the
injunction?
appropriate order. That
Not
is
that.
11462. No, this is an application for extension of interim order.
Yes.
This is not for appropriate order.
Can 3, there is a can 3, Lord.
Yes, yes. Can
Can
3
three.
old number is 11462. An order extending the interim order on 26th of July 2018. Lastly extended on 30th of November.
And fixed, monthly list.
Then I am disposing of this
Fine,
application.
Lord.
Nothing remains in this application.
This is, it's a trust matter, Sevait matters, kindly do not.
Only not today.
Next week he will.
No.
He personally
Maybe.
requested me.
Then I shall direct this matter to go out of the list.
No, that kindly oddly.
No.
Yes.
Monthly list.
No. Yes, next.
25.
Your Lordship. I am for the petitioner, Your Lordship. Appearing counsel, Mr. Amrita Mondal, he is now out of station. Kindly give me not today, Lordship.
125.
Yes, my Lordship.
Yes. What are you challenging?
My Lord, I am not this.
You are not in this matter.
I am just instructed by my senior, Lordship.
What is your name?
Shipra Noshkar.
Not today. Next.
My Lord, 126 item number is kindly give me not today, Lordship also.
126.
Yes.
Kindly give me not today, Lordship.
I am directing this matter to go out of the list. You will get the matter listed, then you will be praying for adjournment.
Kindly not today. He is now out of station, Your Lordship. Kindly,
Let him mention after he comes to the station,
kindly, not today.
not today.
Much obliged.
Yes, next.
127.
My lord, in this matter, Sujit Roth appearing for the petitioner, my lord.
Who is appearing?
Sujit Roth.
Yes.
Due to his brother died, my lord, he going to native village, my lord.
When do you want?
I am paying 1 week adjournment.
As prayed for by the learned advocate, the learned advocate, Mr. Such and such learned advocate appears and submits that there is a bereavement in the family of the learned advocate appearing for the petitioner. First of he prays for a week's adjournment. As prayed for by the learned advocate for the petitioner, list this matter in the monthly list of February 2025 under the same heading. Next.
Monthly list February.
Monthly list of February.
Yes.
1 week you said.
Yes, yes.
Yes, next.
128.
Lord, I appear to the petitioner. Lord, the petitioner was dismissed from service on the only one substantial charge is that he refused to take food.
He refused to take
food.
Food.
Yes, my lord. Kindly have a look at the order of dismissal order, my lord. It is appearing at page number 46.
You have preferred an appeal?
Yes, my lord, I have preferred a statutory appeal. That was rejected.
Page?
Rejection is appearing at page number 53.
Page
Rejection
53.
order. Yes. Last annexure. And in support of my contention, my lord, I kindly allow me to cite one judgment of the Supreme Court, my lord.
On what issue? What is the point which you are trying to canvass in this petition?
Same point. Same point. That
what is the first place the facts, sir?
Yes, my lord.
Law will come thereafter.
Yes, my lord. Kindly have a look at the
What is the ground of your challenge to this order?
charge sheet. Kindly have a look at the charge sheet.
Yes.
It is appearing at 44.
Page 44.
Yes, my lord. Using threatening language to his superior officer.
Yes.
Thereafter, disobeying a lawful command, that is refusal to take food. Thereafter, again.
All these charges have been proved.
All
these charges have been proved.
Nothing has been proved, my lord.
Nothing has been proved.
Yes, my lord.
Yes.
Thereafter, 1, 2, 3, 4. 4 charges are with regard to refusal to take food. Thereafter, dismissal order was passed. Next page, my lord, page 46. And there is no reasoning. In the last paragraph, it says that
page
number 46.
46, yes.
Aforesaid number such and such, Atar Singh Rajput has been found guilty of all the 5 charges and sentenced to be dismissed from service. He has been struck off from the strength to such and such. Thereafter, a representation was made. Thereafter, later, they have asked us to prefer statutory petition. Statutory petition was also filed. Next page, that is page 49. And again,
49 is your representation.
Yes.
Against dismissal.
Yes, my lord.
Where is the order considering this petition?
Order is.
Page 53.
No, order is appearing at page 46, which was preferred, the statutory petition was preferred against this order. That was as page 49, and thereafter it was rejected by the superior authority, my lord. It is appearing at page number 53.
Yes.
It was signed by second in command, DNL for Director General.
Yes. What is the point of your challenge?
This point of challenge is that refusal of food is not a lawful command. It is not against the lawful command. If I refuse the food, it is not against the lawful command. So it is not a violation of the any act or rules. That has been explained in this judgment, my lord, by the Supreme Court, Ranjit Thakur versus Union of India and others. AIR 1987, Supreme Court 2386.
No. What was the first charge? First charge was that you have uttered threatening language to the superior officer.
My lord, yes.
So that is also there.
Yes, my lord. It is general outburst kind of thing, my lord.
Yes.
Kindly have a look.
And second, third, and fourth charge is with regard to refusal to take food.
My lord,
And
yes.
as well as the fifth one.
Yes.
This, according to you, cannot be said to be a lawful command.
Yes. Except one, charge one, all are not lawful command.
But charge one has also been proved.
Charge one is general outburst of a soldier.
That has been proved. So you have uttered this language, threatening language to the superior officer.
But the
that is not an offense,
that
according
is,
to you.
That is offense, but it should minor punishment should have been given. Not
punishment.
Yes, my lord. Not.
Where have you taken that point?
Lord,
That for this a minor punishment should have been awarded. Show me that you have taken this point and how it has been dealt with. Why you are suffering rigorous imprisonment for 89 days? There was a previous offense also.
Previous offense also. Kindly have a look. That were also amended. I mean, the charge sheet were amended. Kindly have a look. Page. In fact,
all right. So show me that you have taken this point that this should have been a minor.
Kindly have a look from the very beginning of the petition. Lord, what has happened? I complained that officers are found they are doing Facebook things. They are meeting with the Bangladeshi soldiers, officers, etc. etc. Photograph has also been given, my lord. That was complained to the superior authorities. Thereafter, my lord, first, kindly have a look at the charge sheet appearing at page 35. First charge is that assaulting his superior officer. Second charge is using threatening language to his superior officer. Thereafter, third charge is also using insubordinate language to his superior officer. Thereafter, it was improved.
All right, which judgment you are referring to?
Lord, yes. Ranjit Thakur versus Union of India and others, AIR 1987, Supreme Court 2386.
Yes.
My lord, I have got a copy, my lord. That has not been.
Which paragraph?
My lord, in fact, I don't have any other copy, my lord, but it is in bold letters, soldiers refusing to eat food, whether amounts to disobedience of lawful command, Constitution of India, judicial review, irrationality and perversity, extent of administrative law, natural justice.
Which paragraph? Which paragraph?
My lord, right now I'm not having second copy, my lord. That's why. Problem.
Yes, it does not say that it is, it's on the other hand, it says that it is assume the complexion of certain thing and even defiance of authority and an unduly harsh and cruel reaction to the expression of the injury may be counterproductive and even by itself be subversive of discipline. It goes against you. Are you relying upon this?
My lord, I have to go through this again, Lord. Because the note I have noted that it is not against the lawful command.
This issue was not decided because of the other, but some observations are against you.
My lord, the refusal of food, it might
This
be.
is on refusal of food, contention
It
C.
might be over.
Kindly see paragraph 8.
My lord, by overeating, etc. It has not been dealt over here, my lord.
Ashun. After some argument, the learned advocate for the petitioner pressed for an accommodation to assist this court on the next occasion. In view thereof, the hearing of the matter stands adjourned for
1 day.
For this day. Next.
Much obliged.
Lordship, I'm seeking an accommodation. I'm being led by Mr. Kallol Basu in this matter. Lordship can keep this next week.
Why? You are here.
We are for KMDA, my
I
lord.
am here, but Your Lordship,
Led by Satyajit Talukar.
Lordship, there's a supplementary affidavit and affidavit in reply also, which needs
What
to
is
be
this
filed.
matter about?
Lordship, this is in regard to a cancellation and a penalty imposed upon us. Who's the owner of a KMDA plot? The allotment was made way back in 1993. The KMC, however, carried out the mutation in my name only in 2012. After which, Your Lordship, in 2018, my allotment was cancelled. Thereafter, in 2019, there was a
Because
penalty.
you have violated the clause for construction.
Lordship,
You have not
Lordship.
constructed within that time.
No, Your Lordship, that's the ground taken. But Your Lordship, in 2018 they have cancelled. After that, after cancelling the allotment in 2019, they impose a charge upon me of rupees 99 lakhs and odd for delay in construction.
After cancellation.
After cancellation, that is the pinching point, Your Lordship. And in fact, when this writ petition was taken up, Your Lordship, at the time of the first hearing, Your Lordship, we were handed over the order of cancellation, which we were not aware of. We were only served, we had come up only against the imposition of penalty in the year 2019. When on the first day when this writ petition was taken up, we were handed over the order of cancellation. That was in the year 2018. In that view of the fact, Your Lordships were pleased to grant us a liberty to file a supplementary affidavit Lordship, those served, we are not carrying a copy today, Your Lordship. We want to file a supplementary affidavit and affidavit in reply in the matter.
All right. Not today. Next.
Grateful, Your Lordship.
Much obliged. 130.
Mr. Probal Mukherjee is appearing in this matter for the petitioner. He is on his legs in court number 32.
Not today. Next.
131.
My lord, I appear for the petitioner, my lord.
Yes.
My lord, covered by your lordship's judgment sitting in division bench, my lord, incentive scheme, no financial cap. My lord, by the impugned order, my lord, an interpretation has been given as if there was a that my lord, no financial cap was only in respect of the interest subsidy. That was, my lord, which was one of the incentives which I am entitled to under the scheme.
Who is appearing for the state?
Mr. Adok and Mr. Siddiqui for the my lord corporation. He was appearing. My lordship remembers I have been trying my luck with before this court, my lord, and I have been mentioning, my lord.
But there's a review against this order.
Yes, there is one review. I later, my lord, realized not in respect of those orders where my lord had passed division in sitting in division bench, but there is a review pending.
No, against an order which has been passed
But
by the division
lordships
bench
have
after the SLP has been rejected
dismissed.
by
Yes,
the.
yes, lordship is absolutely correct, and that review is pending. That is one of the, my lord, that
Only
can
that a review
only.
is pending. It has been assigned before another bench also.
Oh, I was not aware of that. But here, my lord, if your lordship permits and I take your lordship through the papers, my lord, lordship will understand, my lord, the frivolous defense taken by the authority, my lord.
But state is not here. In their absence.
My lord, may I pray for this, my lord? Lordship, if next week any day lordship keeps it, my lord, and gives me, my lord, a direction, I'll communicate them. If they are absent, my lord, then I can.
Dr. Learned Advocate appears for the petitioner.
I'm being led by Mr. Chaudhary, my lord.
Mr. Chaudhary, Learned Senior Advocate, appears for the
state.
Mr. Chaudhary, the review is pending against one of the matters of this incentive. I do not know whether, because I have not gone through this matter, whether the same issue is involved here. If a review against that issue is pending.
Review so far as review is concerned, my lord, that is
They can file
after the dismissal of SL. Review is pending in Supreme Court after.
No. High Court.
Oh, that is
dismissal report.
No, that is, my lord, in respect of, my lord, not. I don't think the issue will be similar.
Have you checked up that?
In the sense, similar means all are incentive schemes.
No. Not in that way. The issue, whether in that incentive matter, the issue what is there, whether the same issue is involved here. Yes. Because if a review.
What are we interested in? No matter that, I understand there is some similarity.
Because there are many matters on incentive. Issues are different. Some is on cap, some is on certain other aspects also. So, have you checked up? Have you gone through the review?
All I am saying is, lordship fixes it any day, my lord, so that we can at least, my lord, this also matter, my lord, single bench, then division bench, it will be at least, my lord.
But if a review is pending, unnecessarily an order will be passed, again a challenge. If a final order is passed in the review, then
review has been filed by a matter of strategy by the state because they don't have the money. That is, my lord, our instructions are, and my lord, they will keep the review pending, and my lord, all these matters will be.
One matter has been assigned before another bench, a review. That is what I
want to be here.
My lord, we will abide by that, my lord. At least, my lord, we go ahead with that. Otherwise, my lord, what is happening is, my lord, these incentive schemes, my lord, the government may have its compulsions, my lord. The reviews are filed more as a matter of strategy than out of. Lordship will see, my lord.
One matter. I think after the dismissal of the SLP, a review has been filed.
In Supreme Court, one review is pending after dismissal. Yes. We have the orders.
No, after dismissal of a SLP, review of the division bench order has been also filed.
In Supreme Court also one review is there.
What is the order which you are challenging?
At page 155.
Well, at 155, the challenge is very simple, my lord. There is the order that has been passed has not considered the subsequent clarification letter. Initially, I was entitled to incentive, my lord, with a cap. Then the cap was removed.
The removal, my lord, is there in not one, but two, but three documents. That cap has been removed. Then, my lord, when we ask for that, they say, no, it is all subject to a cap
So
of.
cap of 100%
Correct,
of
correct,
fixed
correct.
capital investment. That is the,
That is,
according to you, there is no cap as such.
no cap, because it is clarified. And I was given a fresh eligibility certificate on the basis of the clarification.
According to you, that cap was with regard to that interest subsidy.
No, my lord, according to me, the cap doesn't apply at all because of the clarification for which a eligibility certificate was reissued to me, clarifying the position. There is a letter clarifying the position. There is a eligibility certificate which is reissued to me, clarifying the position. And my lord, in the order impugned, in the reasoning which has been given, my lord, the two letters which have been referred to are the earlier two letters, but complete silence and my lord, deliberate overlooking according to my respectful submission, so far as the two clarificatory letters whereby the cap was removed. And the interpretation is that this cap is only to be considered for interest subsidy and not for this.
Yes, yes. And I think the person who has passed the order at page 159 is the same person who have passed the order which was set aside by us.
That lordship is right. That lordship is right. Because
Person is the same.
the person concerned, my lord, he was at that point of time the additional chief secretary, he was the same person.
Ground was same.
And my lord, Mr. Datta tells me the ground is also the same.
Ground is also the same. Yes, because some portions of that order cursory glance.
My lord, page 64, if lordship comes to lordship.
Only kindly check up whether that same issue is pending in the review. Kindly check up that. I think in the review for the writ petitioner, in one of the matters, Mr. Abhrojit Mitra is appearing. And in the other matter, Mr. Abhrotosh Majumdar.
That's Billa. Mr.
Which has been assigned before another bench.
Well, I'll check it out.
What is the issues you will be able to?
The difficulty is this, my lord, review is at the instance of the state.
Yes, yes.
Now, if the state does not pursue the review and
review they are pursuing because the petitioners is after them. So
should be, but
so review they are pursuing because the contempt is also there. So it's not that even if the state do not want to pursue, the writ petitioners are seeing that it is being pursued.
My lord, on facts at least, my lord, so far as my lord, we can, if we are able to persuade your lordship will fix it on any day, my lord. That we will also check up. Page 64, lordship will find its absolute clarification, but it fell from your lord.
It is not referred. Impugned order.
And after this clarification, my lord, this 26th March 2010 letter is not even,
IPA.
Not even IPA.
Industrial Promotion Assistance.
IPA, lordship got
it. Lordship has authored the judgment.
I think this issue also was decided by the division bench.
Yes.
Part of, my lord, in the other matter.
Yes.
Which was against that, my lord, SLP was preferred and SLP dismissed.
All right.
SLP preferred, SLP dismissed. That is why, my lord, it will not take much long. My lord, one is pertaining to
Corporation,
Billa
another is
Corporation,
Dalmia.
the other is Ambuja Cement.
Yes, Ambuja Cement.
And both authored by my lord.
Oh, I see. Lordship was the author of both the division bench judgment.
Ashwin. Mr. Chaudhary, learned senior advocate, appears for the petitioner. First up, he submits that the issue involved in this writ petition has already been decided by the Honorable Division Bench in MAT.
MAT 2458 of 20.
MAT 2458 of 2023 and MAT 1965 of 2022.
Has been already been decided by the Honorable Division Bench in MAT 1965 of 2022
SLP order to petitioner
and MAT 2458 of 2023.
MAT 2458.
First up, none appears for the state. First up, the learned advocate on record of the petitioner is directed to intimate the next date of hearing to the learned advocate appearing for the state. First up, list this matter under the same heading. on 28th.
28 আপনি আটকে থাকবেন স্যার।
কেন?
Comfortable মানে 2 PM আছে আমি
Oh, my lord, lordship takes
30th
it up at 20, kindly keep it on 30th, my lord. I understand I have a matter fixed on 22 PM.
30th.
But 29th instead of
30th I can fix it, but
29th.
29th?
29th already.
Greatly, deeply appreciated.
অর্ডার গুলো দিয়ে দিন, ওনাদের আবার লাগবে পরে দিয়ে দেবেন। অর্ডার গুলো ফেরত দিয়ে দেবেন।
We have extra.
We have extra copies if lordship wants to keep it, my lord, because this will be required, this will, we will be extensively referring to.
Yes, next.
32. Petitioner. Here a restoration application is pending.
Restoration?
Restoration. It is filed within time, my lord, dismissed on February 20,
Have
2024.
you served a copy of the restoration
My
application?
lord, I have served, but could not find the my lord, forwarding letter in my file. I have
Then?
served. Mr. Pinaki Dhol and Tapoti Samant is appearing on behalf of the state. Both were served. And the restoration was also filed within time, my lord. It was dismissed on 20th February and restoration filed on 5th March.
What are you praying for? What is the challenge in this petition?
Challenge is, my lord, initially the petitioners are the organizing teachers of a school. Now, initially, all the teachers and non-teaching staffs moves to writ petition jointly, and both were referred to the DI rejected. Subsequently, these petitioners preferred a writ petition, and 2 other teachers preferred a separate writ petition before this court. Now, 2 other writ petitioners got an order of appointment. State went up to the Supreme Court. Supreme Court affirmed the order of the single bench. Now, they are working, but this petition is pending. And all the points which they have, my lord, stated in their opposition, that whether this Madras authority have any power to appoint or anything, all has been discussed before the Supreme Court. All as well, opposition was filed before the Honorable Supreme Court, all the points were taken. Thereafter, their SLP was dismissed and the my lord, order of the division bench as well as single bench was affirmed.
All right. Petitioner is directed to serve a copy of the restoration application upon the respondents, upon the learned advocate. Learned advocate, I think they will not receive after this, upon the respondents করে দিন। Upon the respondents and file an affidavit of service.
Mr. Pinaki Dhol and Tapoti Samant is appearing
I
in this
don't
matter.
know whether they will now
Now,
accept.
recently they were briefed. Recently,
or
they were
তাহলে respondents or their learned advocates করে দিন। হ্যাঁ? After a week করে দিন। Yes. Under the heading restoration application করে দেবেন। Under the heading application. Yes, next.
133.
In this matter, your lordship, I am appearing for the petitioner, your lordship.
Lordship, kindly pass it over. Mr. Jayanta Samanto on the state.
Pass over?
Kindly engage code number.
Lordship, I am opposing this. From 2019, this matter is pending. They have been directed to file the affidavit in opposition. They haven't filed it.
Where is Mr. Samanto? Call him.
The matter relates to your lordship issuing of
Registration of hackney carriages.
issuing of license, your lordship.
Yes, issue is pending before the division bench. Public interest litigation.
No, your lordship, that matter is a separate thing where the PETA has filed this, filed the public interest litigation, lordship.
Registration is also, I think, that is one of the issues.
Subject to lordship's correction, I do not think so. Since 2018, your lordship, the petitioner is suffering. What happened, your lordship, that in the year 2018, your lordship, the petitioner.
But your registration has been cancelled.
No, license has not been reissued, your lordship, renewed.
Have you applied for that?
Yes, your lordship.
Where is that?
Your lordship will find it starting from page number 23, your lordship.
Page number 22.
23, your lordship.
23.
23, your lordship. On 4th of September 2018, your lordship, my client,
No, there is no specific format.
No, there is no specific format. After that, there is, if your lordship kindly.
So I'm directing them to take a decision on this.
They have taken a decision, your lordship.
That is why I asked you, are you challenging any decision? Have
Yes,
they
your
rejected? You said no.
Kindly comes to page number 135.
135, yes.
Now, the grounds they,
That is why I asked you,
Lordship
have
has
they
got
taken
it.
a decision?
If your Lordship kindly comes to point number 1, these are the grounds they have stated why the license shall not be issued, the renewed rather. Now, may I read it over for your Lordship? Granting additional cart license shall not only augment congestion but also disrupt the free flow of traffic. 2, the space available to cater to the existing fleet of hackney carriages is in itself very minimal, and addition to the same would severely impede normal traffic movement and encroach upon the main carriageway. Point number 3, it is also imperative to mention that as many as 3 other applicants have applied for fresh license in addition to the petitioner, which takes the total count to 13, including 5 new license application applied by the petitioner. In this context, if the prayer of the petitioner is favorably
Are
considered.
you owning the horses also?
Yes, your Lordship. Yes.
Now you do not have any registration.
No, Your
What are you
Lordship,
doing with those carriages now?
They are lying in my.
And horses?
Same, your Lordship. Same.
Where are you keeping them?
My place, perhaps. I do not know where I'm keeping them as on date, but they are not running in the streets, your Lordship. They are not running in the streets. Now, initially, this issue was raised in the year 2012 in a separate set of litigation, your Lordship.
All right, come on Monday. You ask Mr. Samanto to appear to take instructions in this.
Then my Lord, kindly keeps it on Tuesday, Lordship. Monday, I will not.
As paid for by the learned advocate for the petitioner, list this matter on 28th of January 2025 under the same heading. Next.
134.
So also you take instructions where you are keeping those horses. What is the condition of your horses?
I shall.
134. Pass over next.
135.
I'm for the petitioner, my lord.
Yes.
This is, my lord, for the second time Lordship is calling this matter, my lord. On the first occasion also they didn't appear. The petitioners are, my lord, contractual employees.
Opposing?
My lord, the main opposing respondent would be the municipality. Contai, municipality?
Who is
Midnapur,
appearing?
not Contai. Mednipur municipality.
Who appears for Mednipur municipality?
তারপরে we have sent several notices. My lord, Onami Sikdar was appearing. Thereafter, my lord, after he had passed away, we had served notices, and this is the affidavit of service also to that effect. Subsequently,
what are you praying?
My lord, I am challenging an order. Point is that, my lord, the petitioners are contractual employees from 1997 onwards. Admittedly, more than 30 years on all these things. Now, my lord, after the Umadevi, there is a stop in regularization. So, therefore, in 2010, Lordship also has dealt with these matters on many occasions. 2010, the state government at that relevant point of time bought a, my lord, scheme by which their services would be protected till 60 years, and they will be getting 1 lakh of, my lord, not pension. It can be said that goodbye allowance. Now, my lord, that was reviewed in 2011. 6 November.
Amount has been enhanced.
Yes. And subsequently, it has been enhanced. The pay has been enhanced. The day-to-day pay has been, the month-to-month pay has been enhanced. And now it has been enhanced till 2019. Now, 2006 November 2011 is the main notification, which says that in what circumstances what are the circumstances under which a person will be construed as will be getting the benefits of 2011 notification. Now, my lord, in that notification also, it says that from now on, if a department or any person authorized would put someone in contractual appointment, it will be at their responsibility, with a caveat that if that appointment is made in a post which is not sanctioned, then they will not get anything. That is the proviso there. Now, what has happened? This writ petition is before your Lordship. This is the third round of litigation where a rescind order has been passed, my lord. They have been, my lord, praying.
You are challenging a rescind order.
Yes. They have been praying that they should be granted this, whatever are the benefits which are following from 2011 continued notifications till 2019. Their pay will be enhanced and all these things. Now, my lord, this application, this writ petition is, my lord, challenging an order by which the authorities, even admitting, it's admitted that we are 30 years and all these things, have relied upon a report which has not been given to us and has passed an order saying that the posts that you were being employed were not sanctioned posts. So therefore, this will not be, you will not be covered under the scheme, under the notifications, which is totally misconceived. If
According to you, you are appointed against sanctioned post.
I am not required to be, this test itself is not required to be applied, whether it is sanctioned post or not.
Whether appointed against sanctioned posts or not, you are entitled to the benefits of that
Yes,
circular.
sanction post point would be coming in respect of appointments in contractual posts made post 2011.
Made post
2011 notification.
Show me that notification first.
First notification would be 2010 notification, page 62.
But I think state's presence is also necessary. Who is appearing for the state?
Served, my lord. Affidavit of service is also there. Twice it has been served.
Sushanto Pal.
Sushanto Pal was appearing at one relevant point of time. Yes.
Can you not inform him?
No, my lord.
Appearing, we have served upon GP.
Acha. My lord, my learned junior called him, Mr. Pal. He said that I am no longer appearing, and thereafter it has been served upon the GP.
On the GP?
Yes.
And has now been entrusted.
They are again saying that
you don't know. There's a procedure.
We have gone there, but they have again said we don't know. You have to serve it again.
Afresh. Who has said?
The GP office of the GP.
This is kindly sees the affidavit of service, page 5. Affidavit of service ta dilam. Acha. This has been served on 1st February 2024. This was the writ petition was again served. Page 3 is the advocate and records or my lord, communication. Kindly sees writ petition along with all annexures. Along with the municipality. Municipality has also been served. Next page is page 6. This is the delivery confirmation, February 2024. Thereafter, the matter has been appearing in many benches.
Yes, which document you are referring to? Page
62 is the first document, which has been superseded, but only to understand the logic manner I am placing page 52. This was a very simplistic kind of order. After careful consideration of such and such, governor has been pleased to allow that these casual stroke daily rated workers who are remaining attached to various urban local bodies for not less than 10 years as on such and such have rendered service of 240 days. The said workers may remain engaged till 60 years and thereafter pay ban. Now, this was revised. Next page is the enhancement of remuneration will be paid with effect of 1st July 2010. Now, 2011 notification comes in page 79.
79.
Yes.
This is now in force.
Yes, now in force.
So you are entitled to benefits
if
of
I am
increment as per this 79.
Yes. Reviewed, my lord, enhanced on several occasions. May I, the object of this has to be seen.
Yes.
In order to provide security of tenure, appointee emoluments and certain terminal benefits subject to fulfillment of certain conditions to the casual to daily rated contractual workers who have remained engaged in various government establishment for a considerable period of more than 10.
Mr. Laidi, kindly show me your appointment letter.
Now, these are all admitted, madam. I'll just show. Yes.
One appointment.
Yes. Kindly comes to the roll, page 69 onwards.
Page 69.
69, yes. A process was initiated for regularization, my lord. 69.
No, I'm not on this. Show me your appointment letter.
It is there. I'll show. Page 70 onwards is the list.
Yes.
Now kindly sees, come to serial number 29.
29, yes.
Is petition number 3.
Yes.
Ashish De. Now kindly comes to date of first engagement.
No. I've show me your appointment letter.
Later, my lord, as such, there might be, but this is in entire tenure, my lord, these are all admitted.
No. Admitted. I want to see the later ones.
In the impugned order also it is admitted. They are not disputing that we have not been appointed for 30 years.
All
The
right.
reasoning is totally different. I
All
can
right.
show it from the impugned order also.
All right, page 79 you are placing.
Yes.
Yes.
Now, who have remained engaged in various government establishment for a considerable period of time, more than 10 years in connection with implementation of various scheme projects such and such, Department of the Government, 2 memorandums dated such and such were issued by the Government in Finance Department. The previous memo I have drawn your lordship attention. Question of making the provisions of the 2 aforesaid orders more effective and suitable to the convenience of the government established organization as has been under active consideration for the government for some time. After careful consideration of the matter in supersession of the aforesaid orders and all other orders issued by the department in the matter, the undersigned is directed by order of the governor to say that the governor has now been pleased to order that the casual stroke daily rated contractual workers who are remaining attached to the various establishment of the government such and such for not less than 10 years continuously as on 1st August 2011 and have rendered service of at least 240 days each year will be allowed the following benefits. Now, these benefits follow pay ban and all these things. Point number 2 is there. Any entry point basic pay band 1. Now kindly comes to the part which they are relying upon.
10. X.
9 and 10. 9 would be important.
Yes.
It is reiterated that officers responsible, these are the, my lord, benefits. Thereafter, they are carving out exceptions. It is reiterated that the officers responsible for any further engagement or such casual stroke daily rated contractual workers will be personally liable for violation of this order. However, having regard to the exigencies of the situation in order to facilitate smooth running of any project administration or for serving academic interests such and such, it is absolutely necessary contractual engagement may be made for a limited period not exceeding 1 year. This engagement shall be made on strict observation of the recruitment rules and against sanctioned vacancies. Advertisements shall be published in the newspaper and the applications shall be invited from eligible candidates to fill up those temporary vacancies. Simultaneously, steps should be taken to fill up vacancies on regular basis following recruitment rules which are never done. Such contractual engagement may be renewed from time to time but not exceeding a total period of 6 years. No claim for regularization of these contractual services in terms of such and such shall lie. The provision of this order, now while telling, my lord, this is in respect of the previous clause, will not be applicable where contractual engagement has been made without any sanction post and for any specific project for a very temporary period up to 6 years. Now, kindly reads this 6 years with the previous clause 6 years. So this clause is in respect of item number 9. 6 years. Kindly compare 6 years. This is the test. For a very temporary period up to a maximum of 6 years or winding up of the project whichever is earlier. Thus, in such cases, steps will not be required to be initiated or filling up the post through regular appointment as per the recruitment rules since the posts are temporary nature. Now, my lord, in Umadevi also, it was the tenor of the Supreme Court judgment that there will be no subsequent contractual appointments. And if contractual appointments are made, then that regular recruitment, my lord, should be made, which is never done. Now, my lord, in this, entire thing is following the, my lord, so that, my lord, the contractual employees should get something.
Yes.
Now, my humble submission is that this clause 10 cannot be read in isolation.
According to you, this 10 refers to 9 only.
Only because 6 years. Kindly see. And from clause 9 onwards is the exception which is being carved from this order. From 1 to 8, these are the benefits which will be given. It is in the form of a proviso. Provided you will not do any further, if it is done, personal responsibility. And subsequently, if it is done to address the exigencies of situation, not more than 6 years. And thereafter it says in 10 that also has to be in sanction clause. Quoting this.
What happened? You have been terminated.
No. We have been, my lord, praying for this, my lord, several writ petition previous occasions. Kindly comes to page 95. This is the first writ petition in 2014.
What is the order which you are challenging?
Now kindly comes to the order. 119, 18, 19.
Yes.
Now, first paragraph is reiteration, hearing such and such. During hearing, learned advocate for the petitioner submits the benefits of such and such. On behalf of municipality, documents regarding engagement of these petitioners and brief history has been furnished. During hearing, executive officer of the Midnapur municipality has been asked to make written submissions of the municipality with relevant documents specifying relevant resolutions, appointment letter, change of work status, vacancy position as per sanction strength of respective years, and clearly mentions whether the 31 petitioners have been engaged against sanction strength or not. Accordingly, letter number such and such was issued. Next date of hearing was fixed on such and such. Next hearing was held on 7th January 2020, wherein the representatives of the municipality finance department made submissions that these casual employers were not engaged against sanction strength and therefore may not come under the purview of the memo as per such and such. Besides, the brief history dated such and such signed by the administrator of the municipality reveals that these petitioners were casual workers on consolidated pay. This has not been supplied to us. This was also decided hearing that the direction to given to the concerned institute to furnish name of the petitioner along with full address such and such where and whether engaged. Accordingly, letter dated. Now, administrator municipality kindly comes. Administrator Midnapur municipality, while his memo dated such and such furnished some required documents directly from the department without verification from the end of DLB. From the report of the Midnapur municipality, it appears that the writ petitioners number 1 to 24 and 27 to 29 have been working under the Midnapur municipality for not less than 10 years as on 1st April 2010, and they have rendered service for at least 240 days each year. And all the petitioners have been engaged against sanction strength. It was there. This is by the administrator, not by the municipality. But the said report of the municipality has not been ratified from the end of DLB.
Yes.
As to whether the petitioners have been engaged against sanction vacant post or not. Municipality says sanction vacant post. We have not been given. I am putting my case at the highest pedestal.
You were appointed in which posts?
Well, all Group D, my lord. The post of, yes, all, my lord.
The total number of sanctioned posts of Group D in that municipality.
I don't have any idea. This has not been given to us, my lord. We have been appointed as, my lord, tax collector, peon, thereafter, my lord, typist of department, LDC, thereafter, Muzdur. All, my lord, downtrodden people, my lord, that the last, without whom no municipality can run. In fact, no establishment can run. And when they come, they are shown all these things. Muzdur, Conservancy Department, my lord, most of them are Muzdurs. Petition number 1 is clerk. Now, my lord, the reasoning part of the order is that page 121.
Yes.
Third paragraph. Second paragraph, only petitioners have made another jointly signed prayer before the commissioner such and such that the mere subsistence of poor employees have been rendering service in the municipality be ensured by giving effect to order dated such and such. Previously, DLB by later dated forwarded copies of documents submitted by the Midnapur municipality for necessary action from the end of department has mentioned that
Only
after
reasoning is that you are not appointed against sanctioned post.
yes. Now, if this reasoning is taken up, then well, the entire tenure and the object of 2010 and 2011 notification, which is being continued from time to time, goes. The object of the notification is to provide some.
So there are two things. First is whether you were appointed against sanctioned posts or not. Is it your case that you are appointed against sanctioned posts?
It is appearing from the order, which has not been given to us. This communication
was your case that you are appointed
not
against sanctioned
needed.
posts.
I'm putting my case at a higher pedestal. At that relevant point of time, 1997, all these things, well, it is not possible for us to, go into the roster of the municipality and ascertain that as to whether we are appointed in sanctioned post or not. And the municipality will not be obliged to show the records of 1997 after so many years and after 2011 itself. Because anything before 2011 is a different thing. So we will not be shown as to whether it is, we have to depend upon the municipality with regard to the roster and with regard to the strength and all these things. Now what happened at this relevant point of time, when this hearing was going on, there was an administrator in the municipality who is a civil servant. Now, my lord, he, as it appears from the order itself, page 120, made a detailed inquiry and had furnished some documents from where it is recorded that municipality stand was they are all have engaged against sanctioned post. But the said report of the municipality has not been ratified by the TLB. Where is the provision for ratification? If the municipality says sanctioned post, they have to be considered as sanctioned post. And I cannot say that I have been appointed in sanctioned post because I don't have the document. If I say so that I have been appointed against sanctioned post, now if it is shown that it is not ratified.
That is why, Mr. Lahiri, I asked you to show your appointment letter. Show me any of your appointment letters.
I don't know, my lord, whether at that relevant point of time any appointment letters were issued. This is pre.
Mr. Lahiri, I have dealt with similar type of matters. Appointment letters are there. Has to be.
It's not being denied that there is,
has to be, there has to be an appointment letter.
Conservancy workers, my lord, I don't think, my lord, there will be any appointment letter.
There will be appointment letters. You ask your clients, there will be appointment letters.
I'll try to ascertain.
Yes.
Kindly comes one of the decision by which one of the petitioners were appointed. Kindly comes, it is annexed.
Yes.
Kindly comes to page 51.
Page 51.
Yes. This is an order of 2005. Names of Alok Das and Shanmoy Hembram are entered into the master roll as they have fulfilled the terms and conditions of the decision of the board's meeting dated such and such. Thereafter, next is page 52. Pursuant to the board's decision, the names of the following daily rated workers be included in the master roll. Thereafter, one of the petitioners is there, Rajesh Bihari Mahato. Next page is Shopon Mahato.
How many casual workers are there? 77.
We are, my lord.
No. This list which you have annexed at page 36.
Yes.
It appears there are 77.
Yes. Now, my lord, these lists
so how many permanent employees are there? Adding with this, you will be finding it far exceeds the sanction strength.
Now, kindly comes to
Group D of that relevant municipality.
Kindly comes to page 69. What is this list? What is this list? Kindly comes to page 69, this is the forwarding of that list. Midnapur municipality, certified that in continuation with the display such and such, this casual worker such and such who fulfill the conditions as laid down in GO number such and such dated 23rd April 2010. This is that GO, which has subsequently been superseded by the GO of 2011. For a period of 7 days, as directed, such and such, only 12 objections have been received in this administration from various concern. Those objections have been considered necessary. Amendment has been made in the draft list, and accordingly revised and correct list is prepared. This list was being sent to, this was at the process when the process was initiated for regularization.
Page 70.
Huh?
Page 70, what is this list at page 70?
This is the list which is being forwarded by page 69.
Yes. Kindly come to page 70 from right hand column, second one. What is the heading of that?
Post is sanctioned, no.
Yes. All is due. So against all these, it's not against sanction post.
So therefore I am saying,
it's not against.
I am not.
Municipality is saying, not the TLB.
I am not saying.
Municipality's document.
Maybe that is why I am saying that I will not place my case as to whether my post is sanctioned or not.
That is why. So,
my case is that.
So you are referring to the order of the administrator who says they were appointed against the sanction post. This is the document of the municipality which prima facie shows that they were not against sanction post.
And let them produce the document. They have not given us the document. Administrator's document in view of the fact that
if you add the total number of permanent posts, you will find that it will far exceed the sanction post.
That is my point.
Most of them were not appointed against sanction posts.
Maybe that is my point. It is not required. It is not required.
That is a different thing altogether. There are two aspects.
That is why I have opened the case saying that whether it is sanction post or not, it is not.
Sanction posts, then that neither clause 9 nor clause 10 can affect you.
Yes.
That is why I asked you that question. If you are on a sanction post, neither 9 nor 10, in whatever manner it is read, can affect your right.
Yes.
That is why I asked you whether you are appointed against sanction posts or not.
My case is that 9 and 10 would only be applicable post 2011. So the test as to whether this is sanction post or not cannot be applied.
According to
and it is contrary to the object of the notice.
2010, this clause was not there.
No, it was not there. It was not there.
When you are appointed?
97. 96. 96, 97. Date of engagement.
What is the amount of honorarium which you are now receiving?
4,000, 5,000.
Stated anything in your petition?
4,000, my lord.
Where have you 4,000?
If your lordship calculate
the of which order? 4,000 is not with regard to 2010.
No, nothing. They are not giving.
So 2010 also you have not got the benefit.
My lord?
The benefit of the 2010 circular you have also not got.
No. That is when the process was on to bring us under 2010, 2011 came superseding 2010.
Yes.
So therefore, we were not
what you are getting pursuant to which circular, which provision?
My lord, that, my lord, is coming because of the fact that we are rendering, my lord, some of us, while, my lord, this engagement has also been given 1 lakh or something like that.
I think there is one circular of the state which says that enhancement of certain categories of contractual employees.
This year I have annexed everything here.
Where is that? Where is that?
Enhancement, yes.
Not the 2011 circular. Another circular is there.
2019 is there.
This remuneration after 10 years will increase to that.
Yes. 2019. That is in 2019.
Page? Oh yes, I have got page 101.
Yes. Now, my lord, kindly sees. I have gone through this circular. Your Lordship reads and thereafter I'll say something about the circular.
Yes.
May I read it? Yes. 101. With a view to ensuring the optimal use of public funds and to use available manpower in the most productive and effective way in the event of restructuring or winding up of several entities, namely companies, corporation, undertaking, statutory bodies, wholly or partly owned or controlled by the government of West Bengal, at any body which is funded wholly or partly by the government, it was decided in terms of memo dated such and such to redeploy the excess contractual employees, workers engaged by those entities to other entities, organization and government organization under the such and such. So therefore, if there is a winding up, the contractual employees will be redeployed in others. This would, my lord, prima facie not be applicable in our case. I think so. We will be guided by 2013 and subsequent memos.
2010 and 11.
10, 11, 13. 13 has been enhanced.
Where is 13?
Page 82.
82.
Yes. This refers to 2011 memo.
So according to you, now after more than 10 years is 8,500.
8,500.
So this is in modification of 16 September 2011.
Yes, it is written in the top. But there are several misconceptions with regard to the subsequent memo. In some places, the subsequent 2009 memo is also being followed. But in my strict reading, it might not be applicable. There has to be restructuring and redeployment.
Anything more?
Oh, my lord, this would be my submissions. And my lord, one judgment, since this point, my lord, is coming up, my lord, there is I have come across, I have not bought that judgment, my lord. There is a judgment of the Honorable Supreme Court which says that after exploiting and taking away the best years, you cannot subsequently come and say that they have not been employed in a sanctioned post. The point of whether it is sanctioned post or not has to come out from the my lord tenure, that from which fund they were paid. Whether it is sanctioned post or not, this has to be considered. This is only relevant when it comes to payment of funds, whether the funds are coming.
Your appointment letter, everything will be clear.
I will. Next, wait, my lord, if your lordship kindly keep
everything will be clear from that there. And there are 2 government orders relatable to this urban local bodies regarding this contractual appointees who will be regularized.
We don't want.
There is a
As of today,
provision
they cannot be regularized.
There is a provision for that.
That's gone. Everything gone after Umadevi.
After Umadevi, that was done. I've considered in one of the matters. Those circulars. It is after Umadevi.
But 2011 circular is in supersession of everything.
No, here Mr. Lahiri does not say anything about regularization. It will remain as contractual.
That is the point.
One is regularization. There are some circulars which provide for regularization. They are regularization and in a space scale.
Yes.
They will be getting.
Yes.
So that is why provided they were appointed against sanctioned posts.
Yes.
Now here,
that is the concept.
2010 does not speak of sanctioned posts, but 2011
says in respect of subsequent appointments.
That has to be
Interpreted.
interpreted whether this clause 10 refers only to 9 or to the whole circular.
It, in my humble submission, if it so refers, then the entire order, the object of the order goes. Because it was this scheme or whatever is being bought was to give some kind of, my lord, because as of today, my lord, lordship, we follow Uma Devi, while if a individual person comes and says that I want regularization, we are thrown away with the Uma Devi saying full stop in is full stop. Now the same thing when it is made applicable for the respondents.
Uma Devi, there is one exception.
That is
Says-
large scale.
Yes.
Paragraph
scheme can be
58,
paid
everyone.
For regularizing.
Paragraph 51.
Yes.
58.
With regard to that, some government orders have been issued to regularize some
Yes.
who falls within that criteria.
Yes.
And
there is another paragraph also, following which this clause 9 and 10 has been framed, saying that if it is beyond 6 years, you have to initiate recruitment process for regular recruitment. Now, my lord, when the person,
is there, this contract
which is never done. So as of today,
that is a different thing altogether.
yes,
But this contractual is only for a stopgap arrangement for a limited period.
that is clause 9, 6 years maximum.
The process, you have to follow the regular process.
Yes.
In the meantime, you can
Exigencies, which is in respect of clause 9.
Yes.
This engagement shall be first, no engagement, that is in like proviso, page 80. However, having regard to the exigencies of situation, in orders to facilitate smooth running of any project administration or for serving academic such and such, where it is absolutely necessary, contractual engagement, academic interest is also included, so that it may be made applicable to, my lord, other academic persons. Contractual engagement may be made for a very limited period, not exceeding 1 year. This engagement shall be made on strict observation of recruitment rules. So there has to be an advertisement, constitutional process has to be followed, be published. Simultaneously, steps should be taken to fill up the vacancies on regular vacancies following recruitment rules. Such contractual engagement may be renewed from time to time, but not exceeding a period of 6 years. Now, this 6-year standard is made applicable. Provisions of this order will not be applicable where contractual engagement has been made without any sanction post and for a specific period, for a very temporary period up to 6 years. We are beyond 6 years. So this 6-year standard is applied. Or winding up of the project, whichever is earlier. Thus, in these cases, steps will not be required to be initiated for filling up the posts through regular appointments as per the recruitment rules, since the posts are temporary by nature. So 9 says it cannot be beyond 6 years. And if beyond 6 years, you initiate process. পাঞ্জাবের চার্জমেন্টটা বিহাল নাকি পরিস্ট্যান্ডের ডিভিশন বেঞ্চে আমরা ওই পিডব্লিউডি মাঠটায় দেখাচ্ছিলাম শুভদীপ শ্রমিক ব্যানার্জি নাকি না লোকটা আসতে বেটে করবে PWD.
Yes. Yes.
I will show that judgment, my lord. Lordship kindly keeps it. And kindly takes it out of the line. Second
Mr.
time, my lord, it is, my
Mr.
lord.
Lahiri, learned senior advocate, appears for the petitioner. Full stop. None appears for the respondents. Full stop. Affidavit of service filed in court today is taken on record. It has been submitted by Mr. Lahiri, learned senior advocate, that the respondents have been duly served. A senior advocate for the petition that the respondents have been duly served. So please this matter under the heading fixed matters in the next week.
On,
Yes.
my lord, fixed matter as?
Fixed matters. Yes, next.
My lord, lordship is keeping on particular next week, my lord, only excepting Monday, my lord, because
Excepting
Monday, my
Monday.
lord, I am in Delhi, my
29th
lord.
28th করে দিন
28th, 28th, 29th, every day, my lord.
28th January. Yes, next.
136.
26, my lord, I am appearing for the petitioners. Kindly, my lord.
Not today, next.
And my lord, kindly, one line order, my lord, that the, despite, my lord, the communication, my lord, the municipal authority.
Next day. Yes, next.
137.
I beg the petitioner, my lord.
Yes.
Mr. Sujit Kole is appearing for the respondent, Durgapur Projects Limited. Affidavits are complete. Sujit Kole, Projects Limited. The grievance is, my lord, the second writ petition filed. In the first round, court directed petitioner is paying, my lord, one increment for obtaining higher qualification. In the first round, the Honorable Court directed them to consider. They have considered and passed an order
rejecting your
rejecting my claim by holding that your qualification is not conducive to the post that you are holding. So that is the, my lord, point to be decided. The qualification is not conducive to his post. Now, my lord,
My lord, may I file my opposition? এটা আগে দিয়ে দিই।
You have filed your reply.
Reply, my lord, is not affirmed, my lord. My client is extremely unwell, my lord. He cannot come and affirm. Lordship, I will not, my lord, use any reply.
Affidavit in opposition filed in court today is taken on record. Mr. Banerjee, learned advocate, appearing for the petitioner, submits that the petitioner will not use any affidavit in reply in this matter. Yes.
Now, my lord, petitioner was appointed initially as a security guard in the year 1987. Then promoted.
What is the enhancement of qualification?
Enhancement, my lord, in 1999, he got a LLB degree. In 2001, he got not a diploma in social welfare, and 2011 he got a correspondence MBA degree. 3 degrees he has obtained.
Security guard.
So initially he was appointed security guard.
Now?
Then no, junior, retired as junior manager. So managerial.
As junior manager. No, when he obtained these degrees,
Yes.
what was the post he was holding?
At that point of time, my lord, he was holding, my lord, storekeeper. In 1999, when he got LLB, he was storekeeper. Then promoted as senior storekeeper. Then, my lord, obtained the diploma. In
Show me
social-
the impugned order.
My lord. Lord, page 43. So 3 degrees he has got, just not LLB, MBA, as well as not.
So you want 3 increments?
No, only one. But they say that none of the degrees are conducive to your post. So that is not the crux. I say, my lord, that LLB degree is not conducive to any post. I would say. He cannot say storekeeper or not senior storekeeper. He has to, my lord, LLB is applicable everywhere. Apart from that, MBA has also been obtained by him, and diploma in social welfare. I'll place the order. They say none of the degrees are conducive. Page 43.
Yes.
Should I place, my lord?
Yes, yes.
In terms of the order passed by Honorable Justice Rajashekar Mantha in WP number so and so, by which his lordship, by order dated 22nd February, directed the general manager personnel of the respondent number 1, DPL, to consider the petitioner's claim as contained in the writ petition and consider annexure P8 and pass appropriate order within a period of 3 months from date. His lordship further directed that the reasoned order shall be passed in this regard by the general manager personnel of respondent number 1, particularly with reference to the circular dated 16/1/1985, being annexure P8. Then kindly skip paragraph 2 and 3. Kindly come to 3. That there was an office order which was issued on 16/1/85, which has been marked as annexure 8, P8 to the writ petition,
Order was issued by the Chief Personnel Officer, DPL, regarding sanction of advance increment to the employees of DPL, non-officer cadre from 31/5/1984, only for acquiring higher qualification, which is later, if the higher qualification are acquired while in service, which must be suited to the job. That the fact remains that respondent number 1, DPL issued office order stating that a decision has been taken by the board of DPL in the 345th meeting held on 31/5/1984 and also in the 354th meeting held on 19/11/84. Sanction of 1 advance increment will be considered to the employees, drawing pay in grade up to including 500 to 960 non-officer cadre and on and from 1/6/84 on the date of acquiring higher qualification, whichever is later. That the higher qualifications are acquired while in service, which must be suited to the job description and conducive to better output and performance of the service in DPL, provided the expenditure of such higher qualification is borne by the employees concerned. Fact remains that the petitioner Sri Sajal Kumar Sengupta, who joined the respondent number 1 company in the post of security guard under security organization of the DPL on 5/7/87. Requirement to the said post is school final with trained police, paramilitary force, ex-serviceman. That during his joining to the said post, his qualification was HS pass in the year 1988. Sometimes on 18/12/1992, the petitioner was promoted to the post of assistant storekeeper, grade 3 rank against internal circular. That the minimum eligibility for the said post was school final with experience. Subsequently, he passed LLB in the year 1999. That further, he pursued with DSW course under Calcutta University on 4/10/1999. During this period, the petitioner applied and was promoted to the post of storekeeper for internal candidates on promotion. Thereafter, on 12/12/2002, petitioner was promoted to the post of senior storekeeper. Thereafter, sometimes in 7/11/2007, petitioner was promoted to the post of inspector stores on his application in the scale of rupees 4,500, 9,700. That the educational qualification for the assistant storekeeper and storekeeper is the same. That thereafter, he passed Viva certificate of labor welfare officer in the year 2003 from Government of West Bengal. Thereafter, obtained an MBA part-time course for which permission was given on the ground that claim for higher post or any financial benefit shall not be entertained upon completion of the said course. That ultimately on 31/1/2018, petitioner attained the age of superannuation and at that point of time, he was holding the post of junior manager. Paragraph 5. That at the present moment, the petitioner has superannuated from his service with the Durgapur Projects Limited, and the representation which the petitioner has made is only after he has superannuated on 21/7/2020 and after 2 years from his superannuation. That it is matter of record.
Superannuated on
31/1/2018.
After superannuation, you have applied, Mr. Banerjee.
Yes, my lord.
I have kindly consider. Is it not a bar, my lord? If the claim is not for fixation of pay, it is a continuing wrong, my lord. Kindly consider those line of judgment.
Delay.
On that, my lord, the judgment of my lord Tarsem Singh and similar judgments, which says, my lord, that if it is a continuing wrong, because my lord, the fixation and pay, I am deprived every month. So it is a my lord continuing or recurring cause of action.
That is different.
Every month I am deprived.
Have you explained the delay?
My lord,
show me that you have explained the delay.
But I would say, my lord, if it is not time barred, if your lordship kindly even takes the superannuation, my lord.
After Mr. Banerjee,
because
after this retirement, you have applied for that.
Now,
whether a particular qualification is conducive to a post or not, how the Writ Court can decide? They are the best persons, the authorities, according to them, it's not conducive, and it was not also a requisite qualification for the post which you have held during your tenure.
So that is the minimum qualification is not much lower. But
even in the school matters, this higher qualification in the relevant subject.
Yes.
Because there should be some logic behind that. Because you may have acquired higher qualifications, but whether
it is helpful or conducive, that is the test. But I am going to the
so
second.
If the subject is satisfaction, how the Writ Court can decide on that?
If the finding is perverse, your lordship can interfere if the finding is perverse.
Where is the perversity?
On
Where is
delay,
the perversity?
The
authorities, the Writ Court is not an expert in that. What is the nature of the job? For what? Which qualification shall be conducive? How can the writ court interfere with
Lord,
that?
a post, for that not inquiry is not required because his post was junior manager. A manager obtaining degree of MBA and LLB, my lord. It is, my lord, I say perverse because, my lord,
Why you did not apply for increment at that point of
yes,
time?
that is on that, my lord, kindly consider
But
whether
not
it is
at that
if
point
the
of time when you are in service.
they have to,
But that was specific statement that they will not claim.
They have to provide it, my lord. The increment, it is not on the basis of an application. Circular does not say that you have to apply for it. Enhancement, my lord, automatically they should give it.
Automatic. So it was not granted. So you obtained this enhanced qualification in 1997. You waited till
99, 2001, 2011.
first LLB in 1999.
1999.
So from 1999 you waited till 2010.
Now, my lord, somebody else. Somebody else was awarded. This
Have you explained the delay?
Somebody else was not given the benefit.
Maybe.
So he is also.
He was holding the same post.
Not kindly.
The same post.
No, but after superannuation, he was also awarded. So they implemented it. So that is also not cause of action. One. Secondly, the recurring cause of action. My deprivation is a recurring cause of action. Your lordship knows in service matters, if not suppose pension is not given or not a particular.
Show me the clause,
my lord,
whereby you accrue your right of increment. Show me that.
Page 33, my lord.
Page 33. Yes.
Starts from page 33, my lord.
Where is the relevant clause?
Kindly come to page 34, bottom, my lord.
34, bottom, yes.
The board approved the proposal for extension of benefit of one advance increment in favor of the employee of DPL in the grade up to and including rupees 700 to 1475 for acquiring higher qualification while in service, which must be suited to the job and to the better output and performance of the service of DPL during the expenditure for requiring the higher qualification was provided the expenditure for requiring higher qualification was borne by the employees concerned.
Yes.
So during service,
this is the clause.
This is the clause.
Whether the authorities bore your expenses.
No.
That is, Mr. Banerjee, there is some significance on that. If the administration or their company thinks, yes, a certain degree or a qualification will be best suited for a job, then these authorities will give the expenditure for that studies. They will make arrangement to get these employees higher qualification.
Born by the employees.
And higher qualification was born.
By
this is also a qualification.
By the employee concerned. By the employee.
Here
Not
they
the
are not born. So this is also one of the conditions.
No, condition is employee, not the employer. Born by the employee concerned, not the employer, my lord. Then they would have taken this point in the order of rejection. Para 23.
For better output and performance of the services,
my lord.
If they say no, how can the writ court interfere with
They are saying not conducive. They are not saying it is not better output. They are saying
actual assessment, Mr. Banerjee. How can the writ court enter into that?
In case of perverse
factual
if
assessment,
something
according to them, a particular qualification is not conducive. How can the writ court enter into this?
If the finding is on the face of it, not perverse.
Show me that it is perverse. Show me that it is perverse. It's subject to the satisfaction of the authorities.
My lord.
The writ court is not an expert. What qualification is suitable for a particular post?
Kindly comes to page 8 once of the writ petition. Page
8.
Kindly allow me to place this paragraph, my lord. Opposition deal করেছে. Petitioner states that on 6/7/2000,
page 8, which paragraph?
23 at the bottom.
23, yes.
That on 6/7/2020, by memo dated 6/7/20 being order number so and so, respondents have provided the benefit of advance increment for obtaining higher qualification to one Anup Kumar Ghoshal, who was having similar job description like the petitioner and similar higher degrees, if not less. Since the benefits have been awarded to him, respondents should have considered the case of the petitioner also in similar lines. A chart showing the respective job description and qualifications of the petitioner and the said Anup Kumar Ghoshal is set out here under. The appointment date I have given, my lord. In the promotions I have given, he was security inspector, I was, my lord, assistant storekeeper. Then he was promoted to assistant manager and manager in 2015. I was promoted to inspector and then, my lord, manager. Same, my lord, qualification?
No.
My lord.
A person who was in charge of the security,
My lord.
diploma in personnel management may be irrelevant for increasing the efficiency. If you want the Writ court to enter into that, then I can render findings on that. Diploma in personnel management and inspector. So personnel management may be relevant for this post.
Then sir, MBA is not triggered. Management. If diploma in personal management, it is also management. MBA is also management.
What is their reply to this discrimination in the opposition? What they have
Paragraph
stated?
7.
Paragraph
7
23, how they have dealt
Page
with
4,
this.
paragraph 7, I am reading, my lord. I say that the reference of Sri Anup Kumar Ghoshal as stated itself shows that the petitioner's job along with his acquired higher qualification does not match with said Anup Ghoshal because Anup Ghoshal obtained postgraduate diploma in personnel management, which is fit and conducive to his post as assistant manager. Now, my lord, I am also.
But I have said without looking at their opposition.
My lord, then kindly consider, I was also promoted as a manager, junior manager. He is saying that for the post of manager, management degree is conducive. That is
And he applied while he was in service.
No, in 2020.
It was automatically given.
He was conferred. It does not say that it was on the basis of an application. I'll just check up. Check it. Give me 1 second.
7/6/7/2020. This is the next page is not written.
No.
One advance increment. She was given in the year 2020.
So that is not the period of time when I also applied. After this, I applied.
This circular was not available at that point of time.
According to them,
Lord,
they have considered this diploma in personnel management.
My lord.
For that, the other person.
My lord.
So, and he was the sub-inspector of stores. No,
Sub-inspector security.
Security.
Yes. I was also inspector stores. I was inspector stores. He was inspector securities. Everything is matching.
But you have not obtained the degree of personnel management.
Not MBA.
MBA in what? Finance. Your MBA is in finance. In what category you have obtained MBA?
I'll just check up. MBA degree का कौन पता है? I'll just check up. It's not general MBA degree, Master of Business Administration. So it's not management degree.
Business Administration.
So
where from do you find that?
Page 29.
Page 29.
Page 29. And look, the circulars are the internal circulars which were not made known to the employee. When somebody was granted,
Master of Business Administration, but in what subject? Nothing has been stated.
no specific subject has been given, there is the degree.
Mr. Banerjee, kindly come to page 28. Letter dated 18th of August 2007. Point number 3.
Point number 3 will not be entertained.
So, you have given this undertaking.
After that, I was promoted.
Maybe.
After that, I was promoted.
But no financial benefit.
Yes. That is a specific undertaking.
Milord, not kindly consider something. Lord. My specific case is that this
Maybe.
was an internal circular, Milord, which was not made known to the employee.
This was given to
And
you.
This was
Addressed to you. And on this,
Yes.
you are granted permission to allow you to continue that study in MA part-time course in management.
If not these circulars were made known to the employees would not have given this undertaking.
No,
Because
this is a letter,
advance-
not a circular. This is a letter given to you.
Yes.
So have you challenged this?
No, these are letter. These are permission given. But I was not.
And this was a condition attached to that.
Condition attached, Milord. I was not aware of the internal circular. My case is that I was not aware of the circulars because
Maybe since you have foregone this,
because
right?
this was not brought on the public forum, public domain.
Maybe.
Circular.
Maybe.
although passed in 85 and 86, it was not, that is my specific case. They were not made in the public domain. So I was not aware of the circular. This letter has been given to me. Had I been made aware of the circular, I would have said that no, that cannot take away.
When you become aware of this circular,
The manager personnel, can he not take away the right which is given by the board? Kindly consider one more aspect, Lord. This is a right conferred by the board. Can the
Mr.
manager take it
Banerjee,
away?
you have accepted this letter with your eyes wide open. You are having in 2007, you are having a degree of LLB.
My lord,
So you are a legal person.
my lord.
So you did not knew that this he cannot, what he can do. Why did you accept this? You
Because-
should have then and there approached the court
Because, my lord,
saying
we-
no, with these conditions, I am not entitled to. As a matter of right, I can
Thus were
pursue
not
this.
made known to us. I've made a specific case. These were not in the
You are
public
having an
domain.
LLB degree, Mr. Banerjee.
Maybe not, but if the internal board decisions, if they are not made known to the employees, they are not in a position to distinguish whether this takes away any right or not.
What board
Because-
decision? I have annexed the circular.
So, my lord, with this letter, no circular is annexed. It only says that you cannot claim any promotion. This is issued by the manager personnel. Now, kindly see who has passed.
No,
the
for this, Mr. Banerjee, it's not that you will not be entitled to any promotion. But for this qualification, you will not be entitled to any promotion. As a matter of course, whatever promotion you are entitled to, that you will get. You will be not entitled to claim higher post or any financial benefit for completion of the said course.
A benefit given by the board is taken away by the manager personnel. But this is not this clause imposed by a inferior officer cannot curtail the benefit conferred by the board. Can you kindly consider this? Board is
Mr.
conferring some
Banerjee,
benefits.
he is the person who will permit you, because for leave, you may not be
Maybe.
attending the duties for something, for some period of time, because the institution will be affected by that. That the institution has chosen
consider
to.
the submission that he has no right to take away something which is conferred by the board. The board has given a benefit to the employees. That is, but they are not making it.
Show me that you have challenged this. This person did not have the authority to do this. Where is your ground in that? And have you challenged this? Have you stated no pleadings also with regard to that?
This no, because I say it was not known to me. These circulars were not made known to me.
Cannot be. These circulars may not have been known to you, but you accepted these with your eyes wide open that you will not be claiming.
This point was also not decided in earlier previous petition. Now, kindly consider this, my lord. If this takes away my rights conferred by the board, then also the right so far as flowing from the other degrees remains, because I had two other degrees, LLB and the personal diploma in social welfare.
Show me the permission which were given for pursuing the other courses that you have not annexed. You must have obtained permission.
They have not taken the point that I have not obtained the permission. In the impugned order of the affidavit, they are not saying.
Maybe that was not one of the ground, but it is on record. This is on record.
They are not saying that I have not.
Maybe a ground which disentitles you to be granted an equitable relief. You are approaching a writ court.
For that, I need to kindly allow me to produce the permissions if I can find out permission for the LLB degree and the social welfare degree.
This is also one of the additional reasons.
Because they have,
in addition to the others,
they have not taken this point. Now they cannot take this point.
Just somehow while going through the paper, this paper has come to
Mohinder Singh Gilbert. They cannot now supplement by adding.
They are not, because this is you have annexed.
My lord.
It's part of your writ petition. You have annexed. It's a document wherein you have signed. It's not a new ground which is being taken. Wherein you have said that you will not claim on this condition. Permission was given.
This was not my understanding.
Banerjee, kindly think of a situation you have applied for. The DPL says no, we cannot allow you because that will affect our functioning. Could not have pursued that studies, but they were generous enough. They have given you. You have acquired your qualification.
No, it would not
post-retirement, you can also pursue your avocation.
Correspondence course, not so
post-retirement, you can pursue your avocation.
So already started.
Of LLB.
That is not post-retirement. So far as during service, my lord, so it comes down to the limitation, but I have satisfied lordship.
Post-retirement, you are pursuing your avocation of LLB as an advocate.
For some time he has done, but now after a surgery, he is now
completely. Then it dawned in his mind And for that, after retirement, he has filed his
So
representation.
that was in 1999, my lord.
Representation in 2010.
That was
After retirement, you have thought of practicing
Ah.
as an advocate, you have made this
so that
representation.
much I have explained that somebody else having the same post was given, from which we came to learn about this. That is the point of knowledge. That these are the internal circulars I can also claim. That is the point of knowledge so far as limitation is concerned. Paragraph 23. A similar person holding similar
Could
post.
have been, but since you have foregone your right by this,
Now,
you now turn around and say
Lord,
no.
may I humbly submit this, my lord. Your lordship is not taking the clause 3. If they produce not the permission given to this other person, this is a cyclostyle copy. Your lordship will see this is not a letter. They have only filled up the names and not the course. So this is a cyclostyle copy given to every employee. If they can show that
Mr.
the other-
Banerjee, assuming illegally some benefit was extended to a person, are you entitled
I would say
on the
not-
ground of negative equality?
I would say not. This is not
Recently,
illegal.
the Supreme Court has.
I would say this is not illegality because the board is giving the benefit which not the manager personnel cannot. So it is not at all an illegality. If
No,
the benefit is given,
according to you, even by giving that person may have given this if it was a cyclostyle, even then they have given to him,
I shall
could not have been done.
I shall produce.
So that's an illegality. So whether that, since one person has been extended a benefit illegally, whether you are entitled on that ground, on the ground of negative equality.
I get the point. But I'll produce not the permission so far as the previous two are concerned because there are two other degrees. But so far as this not other person is concerned, they have not dealt with. Let them produce the permission given to him, at least not for.
What is your
my
pleading with
satisfaction.
in support of page 28? What is your pleading in support of page 28? What
No,
is
because
this annexure?
case
P6.
will not-
P6 has been dealt with in which paragraph?
It is not there. What your lordship is looking for, that is not there.
No. There is there paragraph 7.
Paragraph 7. P6 is not paragraph.
Paragraph 7.
Yes.
So after obtaining no objection, so without obtaining no objection, you could not have pursued your studies. And this was a condition attached to that. So when a permission comes with a condition, can you bifurcate that? Saying no, permission remains, but that goes.
On that, kindly allow me, I'll try to satisfy your lordship. If the permission, if a condition is illegal, like transfers with
Ought to have challenged at that point of time.
Like clog on alienation.
Mr. Banerjee, you could have ought to have challenged at that point of time. This condition you cannot put.
If I had the knowledge that
No.
this circular,
There are two things.
board gives me right.
There are two things. According to you, this no objection with this condition could not have been granted. This is illegal.
My lord.
So then you ought to have challenged without even knowing of that. That is with regard to an increment. That is with regard to an increment. But this specifically, when it has been said, or any financial benefit or higher post, then it is that there is existence of some circular for which you may be entitled for a higher post or some financial benefit. You are foregoing this right. Having knowledge of that. Now you cannot feign ignorance. I did not have that knowledge. Even if you state that on affidavit.
Very basis of the order goes.
So on this particular aspect, I'll try to, if I get any
Because
judgment.
most of when clause 3 is incorporated, knowledge is imputed.
Permission with a condition, Lord. If
Not
it is
only on that, when
running
clause,
contrary to the governing.
clause 3 has been incorporated, knowledge is presumed of this financial benefit. It will be presumed. No question whether you had subsequently, you can state that. This is presumed.
Only on this limited question, kindly allow me to come back. Only on this question, because what is the effect of this, my lord? Like I'm not transfer, flog on alienation. The clog will be bad, but not the transfer.
Banerjee, you have obtained a benefit on that. You have obtained a benefit.
Not from my service. Degree is not my personal.
Yes. Now you are reaping the benefits of that LLB degree now after retirement.
MBA. So far as MBA, LLB,
maybe MBA, you must be giving some advice in managerial to managers in some capacity. Who knows what you are doing? Some consultancy service you may be running. Nobody knows about that. Ashun.
Kindly allow me on this point, this condition. So when it boils it down to the condition which says that you cannot ask for a increment. I'll
petitioner is challenging.
I'll come back. No, kindly, not.
That to 2 years after
I'll
retirement.
Kindly hear the order, sir. The petitioner has challenged an order of the General Manager, Human Resource, HR and A Durgapur Projects Limited, dated 12th of May, 2021. The order is dated 12th of May
Impugned order is not
because the letter is dated 12th of May. Kindly check up page 42. 12th of May, 2021 in this writ petition. First up, the petitioner.
Yes, my lord. It's the 12th of May 2021. Forwarding.
A representation. Where is your representation claiming for her increment? Which page?
It's 3839. Representation. It's 3839.
Submitted a representation.
Page 38, my lord.
Page 38.
My lord.
Submitted a representation on 21st of July 2010 claiming advance increment, inverted comma mode, advance increment for
2020,
obtaining
2020.
21st of July 2020.
2020. Can we come to the next page, below?
2020. Claiming advance increment for having acquired higher qualification, namely LLB, DSW, and MBA within bracket HR bracket close. The ground on which the claim of the petitioner was rejected was that the petitioner applied for such increment after his retirement and the higher qualification obtained by the petitioner is not suited to the job description and conducive for better output and performance to DPL. Conducive better output and performance to DPL. First up. Record reveals that the manager within bracket personnel, Durgapur Projects Limited, issued a letter dated 18th of August 2007 pursuant to the application made by the petitioner on 26th of July 2007 conveying the no objection of the organization to allow the petitioner to continue the study for MBA subject to certain conditions. First up. Paragraph. After some argument, Mr. Banerjee, learned advocate for the petitioner, pressed for some accommodation to assist this court on the next state with regard to the said, with regard to the effect of the said no objection letter. As prayed for by Mr. Banerjee, list this matter on 27th. Fixed matter. Next.
Can it be 28th? One more day, 28th.
28th. Affidavit in opposition to taken on record for this.
I have some difficulties in 29th.
28th, entire day you have difficulty.
After 2 p.m.
After 2 p.m.
Maybe your lordship.
It may be prior to that even. Let it appear thereafter.
If
Yes,
record, your
next.
lordship kindly comes.
28th. Yes, next.
138. I am appearing for the petition.
Yes.
Right, the state in this matter.
You are for the state.
Your lordship.
I appear on behalf of the Municipal College.
Yes, Mr. Visas.
Here, the selection process for the post of assistant professor in a state level degree colleges of
State level?
degree colleges. Now, advertisement has been made in the year 2018. Petitioner being the scheduled tribe candidate.
You have prayed for striking down the entire selection process.
In the alternatively, my lord, to accommodate me.
After participation and after being unsuccessful.
And also prayer B, my lord, kindly see, he has, my lord, prayed for declaration of ultra vires issue of the notification.
What is the stage of the selection process?
Over. 2018 selection over, 2020 selection also over.
Appointments given.
Every 20 selection and writ petition filed 2022. And writ petition filed not after expiry of panel.
Let me place my case. In the advertisement, there was a column. Kindly come to the advertisement itself.
Mr. Bishas, the affected parties are not before this court.
Service done, they did not choose to appear.
Service done upon?
Upon three private respondents, time and again. Kindly
No,
see,
three private respondents, they have been appointed.
They have been
Only these
appointed.
3 persons have been appointed.
Person have been appointed in terms of
Pursuant to that selection process.
pursuant to that selection process.
All right.
Now they have been served. They did not choose to.
Prayer C. He prayed for, my lord, the each subject in respect of recruitment assistant professor. So, my lord, 42 subject we have, my lord, advertised, and my lord, the 42 subjects has been recruitment has been completed.
In each subject?
Yes, my lord, kindly see his prayer.
You are in which subject?
I am in Sautali subject. My
So,
prayer,
entire thing.
my lord, if the notification goes, then entire goes.
Yes, yes.
And if your
What is
lordship
your
goes-
challenge to the notification?
Yes, because of this contrary to the UGC guideline.
What is the UGC guideline which
I
is
have-
being
I have
violated
all
by
this.
the notification?
That UGC guideline, 2016 guideline, they have not followed.
What is the violation? Show me that.
And specific and without regulation 2012 also they
UGC Mr. Gupta is appearing.
now in the advertisement kindly come to initial my prayer is at page 59.
59, yes.
The upper age limit 37.
Yes.
ST 5 years relaxation.
SC, ST 5 years.
5 years relaxation.
Yes.
I am not entitled to get 5 years relaxation.
For ST.
ST.
Yes.
The person who have been given appointment, they are empaneled as an unreserved category. They cannot be given
Appointed against reserved vacancies.
unreserved vacancy.
Against reserved vacancies.
Yes, they have been treated as unreserved candidates. That rather I say, if the persons are treated as unreserved candidate due to migration from one of the candidate migration from the Bihar, then notification says they cannot be treated as reserved category. And another aspect, their age, they have gone down beyond 42, even assuming they are the ST candidate. Assuming, as on the date of advertisement, their age 43 years or more. Well, kindly come to those documents then.
Yes, what is the next round of challenge?
And next round of challenge, that in the RTI, they have disclosed the documents that I got 50, more than 55% of marks. They have not. They have got less than 55. They are not entitled to be participated being a unreserved candidate, as an unreserved candidate. That is another round of challenge. Now, kindly see why waited. They are saying unsuccessful beyond panel, all these things. I made immediate RTI before the authority concerned, College Service Commission. They did not give any documents to other candidates. They did not even produce the panel or publish the panel with the cut-off marks. Only list of the candidates who have been empaneled. I did not know where is my position with the cut-off marks itself. I shall show everything. Only name, no backup marks. Now,
There is the provision for how this panel should be published? Where is that?
It is there that the Honorable Court, but in a several judgment, Justice Amrita Sinha directed to produce with the backup of panel. They did not.
No.
Rules
for preparation of panel.
For preparation
how
of
the
panel.
panel is to be prepared.
Yes.
Which is the rule governing the
Rule I shall let me I shall bring all these things are right there. Now, if your lordship kindly come to page 98, I made an application before the appellate authority. Appellate authority did not also direct the authority concerned to give the particulars of the documents. Second appeal, the second appellate authority, my lord, after the lapse of some time, directed the College Service Commission to hand over all these documents of the other candidates.
Page 98, what is your submission?
98, it is the private respondents documents.
Private respondent, yes.
Kindly see the date of page 2974. My lord, got it, the column, date of birth.
2974, yes.
Now, as on 1/1/18, as on 1/1/18,
yes,
he becomes 43 years, 3 months, admittedly.
Yes.
Have been given appointment, assuming 42 years relaxation for the ST candidate. As on the date of advertisement, as per clause of advertisement, he must be within the 42 years. His age is 43 years, 3 months, 29 days. I have calculated. Apparent. Next, 99. This is another private respondent. 17/2/1974. I got after the second appellate authority's direction, all these things has been disclosed. Now, if that is so, and if they are the, can you see the panel itself? I've annexed also the panel also. And give me 1 minute time. That page 79.
79, yes.
Category unreserved. They have been empaneled as unreserved candidate. Top.
Yes.
3 persons. Top category
4
unreserved.
persons.
Gurucharan, page
Yes.
79.
There are 4 persons.
Yes, 4 persons. 3 have been given appointment.
Yes.
And again come to my lord, page 98. If they are the unreserved candidate, well, kindly see PG. PG part, page 98.
Page 98, yes.
51.38. Now, marks has been given.
Yes.
PG application academic detail 51.35.
51.38.
38.
Yes.
According to the rule, if that person is unreserved candidate, less than 55 debarring for making application itself.
Less
And
than 50.
on the
Where is that?
contrary-
Where is that?
Yes, rule is there. And on the contrary, my lord, kindly come to my score. I got 60%. I believe so. Just now I am giving this. Yes, page 85. Only to bypass my candidature, panel
85.
85. It is my all RTI sheets documents given by the authority concerned. PG 60.5.
Show me which says that less than 55 they
Yes,
will not be entered.
That notification itself.
Page.
I am giving this. Page 57.
Yes.
Column number 1. Good academic record with at least 55 marks or equivalent.
Column number?
My lord, page 57.
57.
Column
Yes.
number 1 itself.
Oh, is assistant professor, yes.
Assistant professor, all
Yes.
subjects.
Consistently good, yes.
Yes. Kindly see, mark the 55% in a master degree level.
Yes.
So if that person is an unreserved category candidate, and I have some documents that one of the candidates has come from Bihar. I have annexed these documents also. And your lordship kindly said notification column number. Give me 1 minute time. Page 62. SC/ST candidate itself from other state will not get any benefit from SC/ST.
Page?
Page 62. Although my lord, I have hurriedly gone through this without any. Now I am just now recapitulating. SC and SC candidate of West Bengal will get that benefit. Now thereafter, my lord, OBC candidate of other state, SC, ST and OBC candidate will not be treated as any.
Will be treated as general candidates.
General candidate. And the document of that particular one of the candidates I have annexed. So far, my lord, I have collected.
So if they are treated as general candidates, then the age benefit, age relaxation also they will not be get.
37. No 42. And my lord, page 131. Right. Anyhow, my client has collected this document, page 131.
Yes.
Now, Narendranath Murmu, one of the private respondents, category general, he has not applied for even for OBC or ST quota itself.
Yes.
And date of nationality Indian, thereafter state domicile Jharkhand. Is 131.
But he was considered as general.
General.
Yes.
In any case, if
has to be considered as general, so there is no
question of ST. It is by better candidate that I am ST. Having academic more.
But according to you, he has been accommodated under reserved vacancy.
Yes.
Show me that. His name has been impaneled under the reserved vacancy.
That panel I have shown just unreserved category lists. Just now, I am giving this another example panel.
Yes, he is unreserved.
Unreserved.
Yes. So he will be unreserved.
He will be unreserved but accommodated in the reserved category.
That show me that. Accommodated against
there is no list regarding reserved category itself, but one post is vacant for reserved category also in the vacancy list.
No, show me that this Narendranath Murmu was given appointment under reserved vacancy. Show me that.
Oh. The list of yes. In the list, I have got that page 79.
79, yes.
Shown.
No, this is the merit panel. So he was placed under unreserved.
Unreserved.
So not against reserved candidate. So there is no violation.
Violation is that one of the page 131.
Yes.
State domicile Jharkhand. He is unreserved. Mallory is querying that whether he has been accommodated.
From other states, even if he is SC, ST, he will be treated as general.
General.
So he has been treated as general.
But accommodation has been made in a.
Show me that.
It is their duty. Commission did not deny.
You are making a case that they have been accommodated against reserved vacancies. For you to prove that.
All right, next date I shall show. I shall show whether that post they are accommodated is falling under the category of ST candidate. Reserved category. All right. Any day next week. And in the opposition, they have not denied at all.
No, despite my lord opposition, he has not used the reply also till then. I have my lord the categorically because I can my lord show before lordship there is no violation. My lord, my learned friend has not placed entire my lord the notification. Kindly see the notification.
All right.
He has all along my lord trying to my lord mislead before this court.
Mr. Vishwas, learned advocate, appearing for the petitioner, commences his argument but could not conclude due to paucity of time. List this matter under the same heading on 27th.
29. Let it be on
Thursday.
Why? Auspicious day. Why? Monday will not be here. Other matters. Busy lawyers will be having many matters. Let it appear on Monday, then I will consider. If you are engaged somewhere else, I will.
Instead of Monday, Tuesday, instead of Monday, I have
Tuesday.
I have personal difficulty.
All right. 28.
Lord, next
Get
petition.
But next matter is mine, in which I am appearing on behalf of the petition.
I am
My
appearing
my
on the
language is for the respondent says it. Lord, I shall be beseeching lordship subject to lordship's convenience. I'm not pursuing this lord. The lordship may kindly take up matter on 29th. Lord, for 2 days I'm busy, Monday and Tuesday. But I have spoken to my learned friend. He has agreed subject to lordship's approval. Subject to lordship's approval. Item
29th.
29th, Lord. At any time, Lord, subject to lordship.
Fixing a date is a problem.
Lord, I do understand, Lord, but the thing is, there's some problem on my part.
All right, so you
On 29th, Lord.
ask your junior to mention that, because fixing a date is a difficult thing. Particular date time is a difficult thing. If you are in difficulty, mention through your junior, I will accommodate.
Let people not.
Fixing a date is a difficult thing.
that-
I do not know whether I will be,
Whether
this bench will be available on that date. That is the difficult thing.
My learned junior may mention.